right now, I want to introduce Kirsten and Alan. Kirsten is from our Tampa office. Alan is from our got to get out of the habit of saying Orlando, our Winter Springs location, Central Florida, Orlando adjacent, I guess we'll call it. Um, who's Alan? Are you going to be going first?
I'm going to go first, so I'll let Kirsten go ahead and introduce herself for those that are not going to have the pleasure of seeing her for a little while.
Kirsten.
Sounds good. Hello, hello. I'm Kerstin Henze, and I'm a partner and managing attorney of the West Coast office for the firm, which is located in Tampa. Alan and I have actually been colleagues for, well, I don't want to date ourselves,
Yeah,
but
let's just leave it at
That's
that.
okay. You started when you were 10. Do it.
we both started at the Pompano Beach office, which is our main office in South Florida. And then we spread our wings and we went to, separate locations, and now we manage the other satellite offices for the firm. In any event, I've been with the firm since 2010, and I've been practicing almost 18 years, exclusively condominium, HOA, and cooperative law. So I've learned a few things along the way. All right, that's about it. I'm going to cover the second half of this class. Alan will do the first half, so I'll tune out and then I'll come back in a couple hours.
See you a little bit later. Thank you.
Thank you.
Alan, take it away.
All right, thanks, Kirsten. So I'll try and be brief. Kirsten covered most of it, but again, my name is Alan Schwartzseid. I manage the Orlando area office of our firm. Representing community associations is all KBR really does. We represent condos, HOAs, and co-ops. Very rarely will we do anything else other than my mediation practice, which is also limited to this area of law. We've got 8 attorneys who are board certified specialists in this area of law, which basically means that regardless of what anyone else says, the Florida bar thinks we're experts. So haha to everyone else. We've also got a board certified construction attorney on staff. So pretty much start to finish, anything a community association needs, that's what we do. Other than the important work that people like Empire do. So as Jeff mentioned earlier, I'll say the same thing about our firm. If you're happy with the lawyer you're working with, great, stick with them. If you're not happy with them and it's not already us, feel free to reach out to me or Kirsten, depending where you're located. And if you're in South Florida, thanks for attending anyway. We'll make sure to get you in touch with the attorneys from either the Pompano or Palm Beach Gardens offices, because we have 4 total at this point, including actually a 5th that's in Miami by appointment only. Hoping to grow that to the other areas of Central Florida over the next few years, but we'll see where that goes. All right, well, without further ado, since you guys ate up 10 minutes of my time, I will go ahead and get started. And obviously, I do want to say a big thank you to Mike, Jose, and Janet, and all of Empire for doing what you guys do. You know, being a partner on this type of education, I find really, really important. And I appreciate the fact that you guys find the education piece just as important as the management piece, just like we feel about the legal piece. So thanks again. I'm going to go ahead and share the slides.
While Alan's
And as
getting
Jeff,
that ready, folks, if there is no break today, if you need to take a bio break, get a drink, just leave the feed running, do your thing for a couple of minutes, and come on back. So I just want to throw that out there. And for those of you who just joined us, if you have not already done so, please press the chat button. Simply enable it so it shows up. Don't worry that it says disabled. We can still send stuff your way, and I'll go over that again a little bit later. Alan, back to you.
all right, thanks, Jeff. So we now have the slides ready to go. You've got my contact information, Kirsten's contact information already accessible, and I'm sure that Empire would be happy to provide theirs as well. You've got a bio regarding Kirsten and me. You already heard all this, or at least the important parts, so I won't waste your time with it. Let's get right into it. The super fun topic, by the way, I'm being extremely, extremely sarcastic, but it's a very important topic of milestone inspections and structural integrity reserves. Now, as Jeff mentioned, we will probably have a class coming up on Senate Bill 913, or House Bill 913, which is all of the changes coming to this area of law within the next week and a half. So the governor has now, as of this recording, signed that bill. It will become law July 1st of this year. We're recording this on June 24th. So just over a week now, and this will become law. So my guess is sometime in mid to late July, we'll tell you what the law now requires you to do and some of the good things that the legislature finally put into place to protect community associations from some of the really difficult things that they've been requiring you to do since 2022. Moving on. Now, let me start with the reason that all of this is required. If you are living under a rock, you might not have heard about a building collapse down in the Miami area about 4 years ago. I think it's actually, I got an email, it's 4 years ago, either yesterday or today. All of that tragedy resulted in significant new legislation for condominium associations. And the reality is, what it required is two things. One is these milestone inspections. It's basically, and we'll get into detail later, it's a study of, hey, is your building safe? Someone's physically coming out to look at your building. Is this safe to live in? If not, then we're going to shut it down and make sure that some of these defect issues and other issues that might have arisen since the building was constructed are taken care of. Then we've got the additional requirement, which I don't love, but it's there and it's not going away, of the structural integrity reserve study, which is essentially figuring out what reserves does the association need, meaning what money do you need to put away to make sure that you can properly operate and maintain that building on a structural level. All right, so let's dive right into the actual milestone inspection report. It's a structural inspection of the building. That includes load-bearing elements and the primary structural members. Now, all these terms are defined, but it's basically checking the structure of the building. Okay, it needs to be performed by an architect that's licensed or an engineer that's licensed in the state of Florida. Or, now this is distinct from what we can do for a structural integrity reserve study, which I'll refer to as a CEUs going forward, just to save probably 20 minutes in the presentation, since that phrase is a little bit longer. But a CEUs is a little bit different, but this one, the milestone inspection report, is done by a team of professionals with an architect or engineer acting as the design professional responsible for everything. We've seen this come up recently where some engineers and architects are actually stopping this work that they were doing because of that liability and that responsibility. But the purpose of this is not to create that liability. It is to make sure that this building is safe to live in. So the whole goal, and again, as Jeff mentioned, you'll get the slides later, so I'm not going to go word for word. Frankly, I think that's a waste of your time because at that point, we could just send you the slides and move on with all our lives, other than the fact that the state requires that this be a 4-hour class. But it's really just, is there any necessary maintenance, repairs, or replacement of structural components of the building? That's the big important piece that you want to focus on. A milestone inspection is not intended to determine whether you're complying with Florida Building Code or the Fire Safety Code. It might uncover problems with those things, but that is absolutely not the purpose. So understand, this is not the building inspector coming in and taking a look at your building and making sure it's up to code. Okay, this is primarily, is the building safe? Do we need one? Good question. If you're not 3 stories or more in height, as determined by the Florida Building Code, and subject in whole or in part to, and this is the important part, a residential condo form of ownership, you do not need a milestone inspection. So those buildings that are 3 stories or more and are residential condos will need to comply with this requirement. Now, the exclusions to that requirement, you won't need it if you're less than 3 stories tall, as determined by the Florida Building Code. You're not subject to a residential condo, so you're purely commercial, or the portion of the building is commercial. This is where we look at condo hotels and things of that nature. So the portions that are residential are what is subject to this requirement. If you're a single family, 2 family, 3 family, and last year the legislature added 4 family dwelling with 3 or fewer habitable stories above ground, not subject to this requirement. Now, I talked about mixed use and condo hotels. The condo that is residential will be responsible for this. If you need it for a building, the corporate commercial aspect, whether that's the hotel owner or whatever that's called, sometimes this is mixed use, meaning especially in Orlando downtown, you've got some buildings that are, the bottom floor is purely commercial. The upper floors, which could be up to 18, 20 floors, I think, are all residential. So that bottom floor being commercial doesn't mean that you don't need it. Okay, it just means that you might not need it for that portion. And if you do need it for that portion, then the condo or the commercial owner is going to be paying for that portion, that floor. And the residential condominium will pay for every other floor. The association is responsible for costs associated with the inspection, again, attributable to the portions of the building that the association maintains. Now, keep in mind, that means that if the unit owners maintain that area, for example, you might have windows, sliding glass doors, things of that nature that your condominium association doesn't maintain. And by the way, if you're in here and you're in an HOA and not a condo, you're in the wrong class and you won't get credit for this. So I don't know if Jeff mentioned that, but I want to be clear now before you spend 4 hours with us. So you might want to make sure that you're in the right class. You're welcome to stay anyway. But if the association is responsible to maintain it, it's included if it's a residential. If the unit owners or a commercial owner are responsible, the condo owner, and this is, by the way, something your condo attorney will need to take a look at and verify what does the declaration say the unit owners are responsible for, the commercial owners responsible for, versus your residential condo association. It's only the things the residential condo association maintains, repairs, or replaces that go into this milestone inspection as an association expense. When do we need to get it? Well, it needs to be done by December 31st of the year when the building reaches 30 years of age. That's determined by the date the certificate of occupancy was issued for the building. If, because the building's so old, you can't figure out that date, or for example, I think in Miami-Dade County, there was an actual flood in the records building, and so a lot of those records were lost. If you can't figure out, and that doesn't mean you don't have to look into it, but if it's not feasible to figure out when that certificate of occupancy was issued, you're going to look into the date that any certificate of occupancy for any portion of the building was issued as that date to determine when that 30 years starts to figure out when you need to have this done. If the building reached that 30 years of age before July 1st, 2022, you're supposed to have already gotten this done. And I think most communities have done this, even if they haven't done the structural integrity reserve study. Now, if the building hadn't reached that age by July 1st of 2022, but the 30 years was before December 31st, 2024, you've got until the end of this year, 2025, to perform that milestone inspection and get the report. Now, once you've done this, you need to do it every 10 years to make sure that your building is still safe. And what's not in here is if your building became 30 years of age after July 1st, sorry, let me start over. If the building hit 30 years of age after December 31st, 2024, then you'll just go by the date that it hit 30 years. Okay, so the legislature is basically mandating certain time frames for buildings that either were or are now past this 30-year milestone. The ones that are going to hit in the future, you just go by 30 years from that issuance of a certificate of occupancy. All right. And again, every 10 years, you're going to have another one of these done from the date, and that 10 years is calculated from the date you got it done, not from the 30-year date. Okay, the local enforcement agency, meaning code enforcement or whoever locally is going to determine whether the building is safe, can require that the initial milestone inspection be performed sooner, meaning 25 years of age, based on local circumstances. This was something that was used to be statutory, that all communities had to do this, all condos and co-ops had to do this, but it was removed from the statute, meaning you still have only that 30-year requirement in the statute itself, because for some reason, apparently they thought that salt water didn't have a clear definition or proximity didn't have a clear definition, or that it's no big deal and it's not going to cause massive corrosion to be located near salt water. So, this is one. I'm always in favor of less regulation over my clients, these condos and co-ops. But I think this elimination didn't really make a whole lot of sense to me, but I'm not arguing and complaining because frankly, it gave my communities more freedom. The local enforcement agency can also extend the due date. Now, note the word in caps and italics, may extend the due date if you can show good cause that the inspection can't be completed if you've already entered into a contract with someone to perform it and the inspection can't reasonably be completed before the deadline, or there's some other circumstance to justify an extension. Keep in mind, what we're talking about here is they can give you an extension or they can choose to get free money by fining you. What do you think this local enforcement agency would rather do? Okay, so make sure you're getting this done by the due date, because if not, you might put yourself in a bunch of trouble. All right, moving on. The reports that were prepared before July 1st, 2022, meaning you've got some other report that serves the same function, includes the same information, that again may be accepted by the local enforcement agency if it meets the requirements of what a milestone inspection report would need to be done, and it was done before July 1st, 2022. What we're trying to do here, or the legislature was trying to do here, is avoid you duplicating your efforts and expense within a very short amount of time, when in reality, you don't need this for another 10 years. So if that deadline is extended because this is treated as, well, you had to do, for example, Broward and Miami-Dade counties have recertification requirements. If you've just done that recertification just before July 1st, 2022, you only need the milestone update 10 years after the date that was done. That other report was created by someone who would be qualified to prepare a report for a milestone inspection. Regardless of when it's completed, you still need to give the owners notice. So we'll get into those notices soon, but basically you have to notify all of your members that this was done and that the report is available for their inspection and copying. If it's accepted, like I said, if this alternative report is accepted, the previous inspection is deemed to be a milestone inspection, and the deadline is 10 years after that date of the previous version, so the previous report. Okay, we need this milestone inspection. What the heck do we do? Well, you need to give notice to every member that, and also inspection to any owner of any portion of the building that's not subject to the residential condo form of ownership, by certified mail return receipt requested, that this is required, and then notify the owners of the required inspection within 14 days after receipt of written notice from a local government, meaning that the government can tell you you have to do this, as I just mentioned. If you get that notice, you need to notify the owners and also notify them of the date that the inspection needs to be completed. There are 2 phases to this milestone inspection. And I know we're spending a lot of time on this. This is like a quarter of the entire presentation today. That's because the legislature thinks it's extremely important. Keep in mind, if you're in a 2-story condo, I'm sorry, we have to teach this stuff. But please listen, because you never know what your neighbors might be subject to, or you might think it's 2-story and then you find, oh goodness, we're subject to this too. All right, phase 1 is the visual exam. Phase 2 includes destructive or non-destructive testing. Phase 1 is literally just a visual examination of the habitable and non-habitable areas. So what we're looking at includes the parking garage, the roof, the pool, all of it. So it's all areas of a building, including major structural components, and providing an assessment. Is this building safe to live in? Or are there things that we see that are or could become major structural issues? Okay, so it's not just the minor cracks in stucco or in paint, but if it's a major crack in the stucco and that could cause at least one of the windows to fall out, it could cause water intrusion, it could cause other problems, then that person is going to probably have to perform a phase 2 inspection, which we'll get to in a minute. All right, a phase 1 inspection needs to be completed within 180 days, so roughly 6 months after you receive notice from the local government that you need to do it. Please don't wait for the local government to tell you, because then you're being put on a separate timeline that they get to establish. If you go by your own timeline, you also get to maintain your own budget of how to do this properly. And you get to work on the timeline that works for the association instead of what works for the government. Just a practical tip. Completion of phase 1 means that this report has been delivered to the local enforcement agency and hopefully to the association, which is their obligation. If there are no signs of substantial structural deterioration, you're done. You wait another 10 years, you have this done again. You don't need to do anything further. Your milestone inspection obligation, other than giving notice to everyone that deserves notice under the statute, is completed. You don't need to move on to phase 2. Do not pass go. Do not collect $200. stop spending $200. Okay. I won't go into detail about what this might entail as to what is substantial structural deterioration, because in reality, the person that performs that report is going to tell you whether it is substantial structural deterioration or not. Milestone inspection phase 2 can include destructive testing. So this is whatever they feel they need to do to determine what it would take to either confirm whether there is or is not an actual structural defect in your building, or substantial structural deterioration is the technical term. And if they need to go in and perform more testing to figure out what do you need to do to put the building into a safe condition. So that's phase 2. And then obviously once that's done, there are additional reporting requirements that come along with it. If phase 2 is required, then within 180 days after submitting phase 1 report, that architect or engineer needs to submit a phase 2 progress report. Doesn't mean you have to have it completed. Understand that. And your manager should be able to explain some of this to you, but some of it might require a legal interpretation. Understand, your manager is not your lawyer. Do not rely on them for legal advice. They can give you great guidance. They can do a great job of managing, operating, maintaining your community. It is not their job to play lawyer because you don't want to pay for a lawyer. So understand, they are legally prohibited from giving you legal advice. So if it's, well, what does the law say we need to do in this circumstance? That's a legal question that requires an attorney. They may know the answer and still not be allowed to tell you. And this is something we come across frequently. Your manager might be 30 years experienced in this field. They might know everything that someone, even at the level of Kerstin and I, would know. But that doesn't mean that they're allowed to give you the answer that they know. It might mean that they know someone like me that they can call and confirm that they have the right answer, but they can't unilaterally decide to just say, no, we're not consulting with counsel. We're just going to give you the answer. All right. Moving forward, again, we're going to kind of sprinkle some of the interesting stuff and some of the practical into this very dry information. And when Kerstin gets to take over, she gets the fun stuff. So again, I apologize for being a little bit dry, but that's what I get. The inspector that performs this phase 2 inspection also needs to prepare and submit the inspection report for phase 2. Now, here are some of the requirements of what needs to go into this report, who it needs to go to. You're going to want to rely on your attorney when you get all this done. I'm not going to go into detail about this because, frankly, we've got 168 slides, and that's not mine, that's total. But we've got now about 3.5 hours to get through it, and we want to make sure to get some Q&A. So there might be some stuff that I skip. I'll fully acknowledge that. But again, you'll get copies of these. Now, it is important to note the timelines here. Within 45 days after receiving the inspection report, whether that's phase 1 or phase 2, now this is only for milestone, not structural integrity reserve, not CEUs, okay? But within 45 days after you get this report from the person that prepared it, you need to distribute a copy of the summary to each unit owner, regardless of what's in there. So you can't hide information. You can't hide the ball and say, well, we're just going to let you live in this unsafe building. Or, well, we think there might be some work that needs to be done to make the building safe, but we're going to hold off for, I don't know, 5 years, which is common, unfortunately, because people don't want to spend the money. That's what these reserves are for, so that you can't have the justification, we don't want this huge special assessment. All right. You also need to post a copy of the summary in a conspicuous place on the property. The place where you post notice of your meetings is usually the easiest. And then you're also going to need to publish the full report and inspector prepared summary on the association website if you need to have one. We'll get into what those requirements are to have a website, whether you need one or not in a little bit. But realistically, anyone under or anyone that's 25 units or more will probably need one by the end of this year. So just know that. If also the other thing to be aware of is, chances are if you're working with a management firm that knows what they're doing, like Empire does, they're already providing this function to you. There's some stuff that needs to be added if you want them to perform that function, but they will take care of it if you ask. Let's see, the Board of County Commissioners. Oh, we're not going to go through this, but bottom line, the local enforcement agency can tell you after you find that there are structural problems with your building that you've got a year to commence the repairs. That doesn't mean a year to complete them, but a year to commence them. Now, keep in mind, if it's bad enough that you need to be condemned because the building's unsafe to reside in, that means that that building's getting shut down probably immediately, because the last thing that the building inspector wants, or that the person that performed this inspection wants, is to be held liable in some way for a building collapse like what happened 4 years ago. So failure to obtain the inspection is a breach of fiduciary duty if it is willful and knowing. Now that you've been to this class, and everyone is required to attend this class by the end of this the end of this month, in fact, if you haven't already attended the new condo class, keep in mind that the directors and officers are considered to know when the milestone inspection is required. It's whether this was willful that you didn't do it that is going to be the distinction between, was that a breach of fiduciary duty or just an oops and maybe you get away with it. I wouldn't try to get away with holding off on this if you know that your timeline is up for that 30 years. The local enforcement agency can add timelines and penalties. Like I said, they can fine you, they can shut down your building if you don't comply with the milestone inspection requirements that we're talking about today. Bottom line, if you're 30 years old, take care of it, please. Don't make this a big deal, a big issue. It is a big deal. It's very important to know whether or not there are structural defects in your building. So please just take care of it. Again, I don't necessarily agree with CEUs, but these milestone inspections, the fact that Miami and Broward require it, I actually commend, because otherwise most people would not bother to have the building inspected unless they're absolutely required. So this is another Florida Building Commission needs to create rules. We're not going to go through that. And now we get to move on. So we're done with milestone inspections. So let's shift hats that we're wearing for now. We're talking about CEUs and mandatory reserves. So what is a reserve in the first place? Kerstin's going to get into, I think, a lot more detail of what a reserve entails. This is essentially putting money away to make sure that you have the funds to repair, replace, maintain certain assets of the association that you don't maintain, let's say, within once a year. So if it's not an ongoing annual expense and it's going to be, 5 years down the road, 20 years down the road, you just put a new roof on. That's one of these things. Okay, so there were mandatory reserves before. The structural integrity reserve study is going to look into all of your structural components. Okay, so this is the general requirements, and keep in mind this catch-all, which is the only one I'll mention because it's a catch-all. The last bullet here, one of these structural components that you're required to reserve is anything that has a deferred maintenance expense or replacement cost exceeding 10 grand, and the failure to replace or maintain that item negatively impacts any of the structure of your building. So anything that costs more than $10,000 or is one of the things listed here, you have mandatory reserves. These mandatory reserves cannot be reduced. They can't be used for any other purpose because the Florida legislature considers them so crucial, so important, that you 100% must have that money available when you're going to need it or when you expect to need it, which is the purpose of this reserve. Do you need it? And just like with milestone inspections, 3 stories or higher is the current limitation. If your building is not 3 stories or higher, including one of the changes that I will go very briefly into that is coming this year, if you haven't already done this, it's 3 habitable stories or higher that this needs to be done. So keep in mind there is a slight change coming down the pike, and I don't recall whether it's milestone inspections, CEUs, or both. So again, I would suggest that you stop by our class that we're going to have that will not be for credit, but we'll go through all the changes coming that took effect or will take effect on July 1st of 2025. This is another one. It's every 10 years after the condo's creation. So this is not a wait 30 years issue. This is you need to know what money you have right away. So once the condo's created, you should generally know what money needs to be put away. You get this done every 10 years thereafter. Okay, again, exclusions, buildings less than 3 stories in height, single family, 2 family, 3 family dwellings with 3 or fewer habitable stories above ground. It's not in the slide, but 4 family was added last year, and I apologize for that. Any portion or component of a building that hasn't been submitted to condo form of ownership, just like the milestone inspection, any portion or component maintained by someone else, and commercial condos. So a lot of the same exceptions, actually almost all the same exceptions as the milestone inspection report. A CEUs is based on a visual inspection as well. At a minimum, these are the things that it needs to include. We won't go through them in detail because in reality, it's what do you need to put away over the next 25 years is what goes into that report. And it's what do you need to put away each year, by the way. The visual inspection portion of the report needs to be performed by an architect, engineer, or this is the distinction between MERS and CEUs here, a person certified as a reserve specialist or professional reserve analyst. So before it was someone working under a licensed architect or engineer. Now for the CEUs alone, it's someone certified as a reserve specialist or a professional reserve analyst. So this is distinct. So understand, you can't necessarily have the entire thing done by one group. Now you can mash together the milestone inspection and structural integrity reserve study, and that can save you some money, but it'll need to be done by the engineer or architect because the groups operating under them won't be able to do the CEUs portion. So if you want to combine them together, you got to use the actual engineer or architect who has that licensure. The deadline, if the association existed on or before July 1st, 2022, you were supposed to have this done by the end of last year. If you're required to complete a milestone inspection, though, on or before December 31st of next year, you can complete the CEUs simultaneously. Like I said, saving some time, saving some money, and just getting it all done together. But you cannot have a structural integrity reserve study done after December 31st, 2026. Well, let me clarify that further. You need to get it done before December 31st, 2026, regardless of whether you're trying to combine these two together. If the milestone inspection was performed or an inspection completed for a similar local requirement within 5 years and meets CEUs requirements. Now, keep in mind that 5-year time frame is not in the milestone inspection portion. It applies only to the CEUs. That inspection can be used just like the milestone. You could replace it with a previous inspection. And again, the date that you start that 10-year clock for the next one would be the date that this report was issued. Okay, we have it. Now what? Again, 45 days after you get it, you distribute a copy or a notice that the completed study is available for inspection to all of your members. That goes U.S. mail or personal delivery to the owner. You can give it via electronic notice if the owner has opted into electronic notice. You also need to provide the division with a statement saying the study was completed and you provided this to the members. What you don't need to do, because I've looked at, and we tend to do this because, you know, the attorneys at the firm are mostly nerds, but we actually took the time to take a look at the DBPR website where the division has had people check off, have I done this or not, and submitted the report that this has been completed for the community. They also added an option to submit the report itself. You do not need to do that. That is absolutely not required. So my suggestion is if you don't need to give more information to the government, maybe don't do it. That may be the libertarian in me, but just, you know, government, leave us alone. You're already telling us we need to do all this. Now you don't need to tell us that we need to submit the actual report. We're confirming we did it. If you want to confirm that we did it, you can reach out. All right. The CEUs needs to be maintained for at least 15 years after the study is completed. Interestingly, the milestone inspection report portion of the statute doesn't say the same thing. I would keep both for 15 years just because at some point I suspect the legislature will catch that and have a glitch bill where that gets added, and we need to do that the same way. If you need to have a website, the CEUs also needs to be posted on the website or the app that you're using. If you don't do this, just like the milestone inspection report, willful and knowing, it is a breach of fiduciary duty. Now the reserves. If the association's required to have a CEUs, those reserves cannot be touched. So the reserve amount for those items need to be based on the CEUs, not what you think is a better idea. If you disagree with what's in the report, you need to get a new report that will allow you to rely on it. Because if not, if you're not relying on one of these CEUs reports, you are not actually complying with Florida law. Okay, the association can adjust the replacement reserve assessments annually, however, to take into account you've got inflation or any changes in estimates. So for example, your roof, it says it'll last 20 years, you suffer a hurricane, you replace the entire roof. Well, that doesn't mean you have to get a brand new inspection report. What I would hope you're doing is using someone who's qualified to supplement that report, and you can use the updated information for that roof. There are companies that have provided these reports who will provide a supplement at a discount if this happens. So if your roofing vendor is not qualified to give you that, breakdown of what you should be putting away every year, then you can have, I know there are at least 3 or 4 that I've worked with in the past who will actually allow the association to just pay a minimum amount of money. I say minimum, it's probably still more than you want to spend, but you're getting an update rather than, oh, well, we got a new roof, now we need a brand new report. And to spend all that money when it's 3 years after the last one, you don't need to reset that timeline. You can just supplement and update. Now, if you can't figure out how long this thing's going to last, or it's supposed to last more than 25 years, for example, a 40-year roof, okay, you don't need to reserve for those items under this statute. But you do need to reserve for the amount of deferred maintenance, which is recommended by the CEUs for those items, meaning you don't have to reserve to completely replace your roof, but if within 5 years, the vendor that installed it and the reserve analyst or the engineer or architect who gave you your reserve study thinks that there's going to be some maintenance that's required on that roof, even though it doesn't require a full replacement, understand that you do need to put away what's going to be needed in those 5 years. Okay, I mentioned you cannot waive or reduce the amount of of CERS reserves. So those are the ones that I outlined what they are specifically a couple minutes ago. It's the 10K and anything else regarding the structure of the building that's specified in the statute. You cannot touch those reserves other than using them for the purpose for which they are intended for any budget that's adopted on or after December 31st, 2024. So if your budget was adopted on December 1st of last year for this year, it could have waived or reduced those particular reserves. Anything that's adopted now, sorry, but you're out of luck. You got to put away the amount of money that your reserve analyst or architect or engineer told you need for these particular items, and in the amounts that they say is needed every year. For non-structural reserves, you can reduce the amount that you're putting away, maybe even to offset all these other CERS reserves and other expenses that you have coming up for milestone inspection resulted in additional work that needs to be done to secure the building, etc. You can reduce or eliminate for that particular calendar year your non-CERS reserves. You can also use those funds for a different purpose. However, you can't do either one of those things. You can't eliminate, reduce, or use for a different purpose for non-CERS reserves unless you get a majority of all of the voting interests of the community, other than those that have been suspended. So keep in mind, you're not going to be able to use that money for anything else or reduce or, eliminate if it's CERS. If it's a non-CERS, non-structural reserve, you need a majority vote of the members. Okay, and this did change over the last few years. I won't bother going through what it used to be, but this over the last, I think, 2 years, the percentage did change. Using them for a different purpose requires the exact same votes, but again, can't use them for a different purpose for CERS reserves. So pooling was not authorized in the Florida statutes. It looks like that might be changing sometime soon. This says check with legal counsel. That is still the guidance I would give. And pooling of reserves, Kerstin will explain a little better, but it's basically shoving all the funds into one fund for all of these structural items so that when each one comes due, you'll have the money instead of saving all of the money for every single line item every year. What this tends to do is reduce your overall assessments for these CERS reserves because it means that you're putting away less money each year. It's still just basically having just enough money each year to pay for what's due that year. But again, I think Kerstin might do a better job of explaining in more detail because frankly, she's got more time to do it. Moving on to local government intervention, same thing. If the this took effect last year in July, if the building is uninhabitable due to a natural emergency, the board, upon approval of a majority of the members, can pause or reduce the reserve funding or use the funds for a different purpose. Now, this will require a declared state of emergency, and the building needs to be declared uninhabitable due to this natural emergency. Okay, so keep in mind all these things need to happen first, and this is another one. Before you just presume you can do whatever you want because there's been a natural emergency and you guys are declared uninhabitable, contact your attorney. If your attorney is not available during that time frame, find another attorney, because anyone that didn't make a plan to keep their offices accessible when we can have everything in the cloud and I can meet with you via Zoom is not the right attorney. Moving on, milestones, inspections, CEUs. What else do we have to deal with? Well, now we've got the developer being required to provide this structural integrity reserve study. Now, guess what we're going to do? Ignore it to some extent, but get it. And I don't mean ignore it as in, well, if there's a problem, don't do anything about it. I mean that you're going to want to have your own studies done. And I say that about every turnover. You want your engineer to come out and look at the entire community. The reason for that is that although these engineers and architects and groups that work under them are legally obligated to do this the right way, they can potentially find reasons when they work with these developers and do, 50 to 100 of these studies for the same developer, they might be slightly biased even though they're not supposed to be. I'm 100% not naming names. I don't know that I've worked with any that I've found to be biased, but I know the risk is out there because I've seen it in other aspects of developer turnover. So I'm just suggesting that once that developer turns over control of the community to the members, this is one of those documents you're supposed to get within 90 days thereafter. Keep in mind, you might want to get your own study done, but it's basically the very similar to what the CERS is going to be, but for specific components. Now, this is unit owner disclosures when you're selling. I'm not going to go through them because it's not an association obligation, but be aware that there are specific requirements that resulted from this building collapse as well. Disputes regarding the milestone inspections and CERS. Now, I don't know why the legislature said this is effective July 1st, 2027, when in reality the requirements to do these things kicked in 2024. But we'll ignore that for now and say that the term dispute, meaning that you go to pre-suit mediation, and by the way, this is not subject explicitly to non-binding arbitration, which is the other option in most situations that are included in a dispute. But a dispute will include failure to obtain a milestone inspection or CERS, or to fund reserves as required under the CERS, or to make and provide necessary maintenance or repairs that are found in a milestone inspection or CERS. So basically, if you don't comply with any of these, it's not only a breach of fiduciary duty, but it's also something that the association can be found liable for, but you go to pre-suit mediation rather than going straight to court. I think this is probably a good idea. I think the legislature was looking at it as we're probably going to have a lot of people that don't do this because it's not easy to do. So we want to avoid inundating the courts with new lawsuits and see if we can resolve some of these things with a settlement in mediation before people are allowed to go to court. All right, you got through the first half of Alan's presentation. Congratulations. Next, we get to elections and official records and record keeping. Super exciting topics. I get the most fun out of everyone when we do these presentations. So thank you so much, Kerstin, for agreeing that I could have the first half. Time required it, but not exactly the most exciting information to share with you guys, but I'll do my best. When do we need an election? Well, when there's a vacancy on the board caused by the expiration of the director's term. That gets filled by electing a new board member. What does this mean in plain English? At the end of the year, if you don't have staggered terms, every director's term expires. You need an election to fill that role. Okay, a vacancy on the board that's caused before the expiration of a term, except by recall, gets filled by a majority of the remaining directors, even if the directors are less than a quorum, or by only one director if that's all that's left, or the board can hold an election to fill the vacancy. Now, you've got the option to go through this entire procedure, or the board can say, I want that guy. Why would you spend all that time and money if you can literally just have a board meeting and make this decision? So my recommendation is almost always going to be just appoint someone to fill that role until the term expires. If you can't find anyone to fill that role without having to have an election, that might be one reason to choose to have one anyway. But why spend the time, spend the money, and go through this hassle of the timeline that I'm about to go through if you really don't need to? Now, here's the timeline. There are 4 crucial days that you need to know when we're talking about a condominium election. 60 days, or actually not less than 60 days before the election, you need to provide the first notice that basically says, here's the time, date, and location of the election. It's also going to include the form to fill out if someone wants to be a candidate for directorship. Within 40 days, not less than 40 days before the election, those people that do want to be candidates, meaning they want to serve on the board or at least be considered for that purpose, need to fill out and return their nomination form to the association. Okay, if that doesn't happen, they're not eligible. Someone who didn't submit that form can't serve on the board, at least as being elected at that election meeting. If the candidate provides it, meaning they don't have to, but they can also provide a an information sheet that gets included. You do not get to control what's on that sheet, and you may not like it, but it's basically one piece of paper, 8.5 by 11 or smaller, that gets, pardon me, included with what you're mailing out as part of this election process. It's going to be sent to all of the members so that everyone has the same information about each one of the candidates, and it's the information that the candidates wanted to share, not what was cherry picked from, what the board wants to share with all of the members. Now, I mention this not because I think it's crucial to know, but I think it's important to understand. Again, the board doesn't get to select what information goes on there. Even if people are bad mouthing the board and saying these people did a terrible job, they were self-dealing, blah, 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 the directors get to respond by putting information in their own information sheets. Or, although not preferred, you can respond by sending out your own communication as a board. Okay, but I would not recommend that you get into this flame war with someone who wants to serve on a condo board. Because honestly, if it's that big of a battle, is it really worth it to serve on your condo board? I mean, I don't know what you guys are getting out of this as directors. I applaud you for being in this class and spending 4 hours of your day with us. I think it's laudable. I think it's a very difficult and thankless job to be a board member on a condo or co-op board. But I don't know that it's something I would fight for. But that's up to you. All right, moving on. Not less than 14 days or before 34 days before the annual meeting, the written notice, this is the second notice that goes out along with the agenda for the meeting, the information sheets, and the balloting information and documentation. That all goes out to the members. So moving on, the number of directors, and we'll get into what goes with the ballot in just a minute. Unless the governing documents say otherwise, you have a 5-member board. If you have 5 or fewer units, the board is at least 3 members. Now, your bylaws might say that there's a range. It might say that you have, no less than 3 or greater than 9, or it may specify a number. Keep in mind, you need to have a board vote if you want to change the number. I have a lot of people that say, oh, well, you have to have that board vote before the election. Why? I don't know of anything in Florida law that says that, unless your governing documents specify what the timeline is for making that decision. Okay. If the articles or bylaws allow you to serve for longer than a year, the terms expire at the annual meeting. Unless the condo is a timeshare or non-residential, the staggered term of a board member doesn't expire until a later annual meeting, meaning that person's staggered terms is basically serving on the board for 2 or 3 years. Okay, so that means you're not going to be reelected within that next year's election cycle. So you stay on the board, even though there might be 1, 2, or 3, however many people that are going to be elected at the next election. You're not. You stay on. And then if all directors' terms would otherwise expire, but there are no candidates other than the people that are on the board, or there are no candidates at all, and the board basically said, I don't care if anyone else gets in. I don't need to serve, but I'll stick around if I have to. There's no election required in that circumstance. So keep in mind also, if you've got less or an equal number of people who nominate themselves and are eligible candidates compared to the number of open spots, the number of vacancies for that year's election, there is absolutely no reason to hold an election. What are we electing? The people that automatically get in? What's the point? So you're not going to hold an election in that instance, but you will have the annual meeting still because that is something you're obligated to do. So you'll skip the election, you'll have the annual meeting, you'll have your organizational meeting, which is where the directors basically decide who the officers will be, but you won't have to have the election itself. Now we get into term limits. You have an 8 consecutive year term limit unless it's approved by 2/3 of the votes cast in the election to have that person back on the board after that 8 consecutive years is up, or there aren't enough eligible candidates to fill vacancies on the board. Now keep in mind, this came into play in 2018. So if you're talking about a 2025 election or an election where the term will end before July 1st, 2026, this doesn't apply because it's not retroactive. So it's 8 years starting on July 1st, 2018. If you came on after that, then the date that this will kick in for you will be even later. Okay. Now, people ask me, well, how do we stay on the board? Make sure that 2/3 approve. 2/3 of the members actually, or I'm sorry, 2/3 of the votes cast in the election say that you can stay on, or there aren't enough eligible candidates to fill the vacancies, or you can get a little creative and you drop off for, let's say, a week. And then at the election, you get reelected. That would, to me, be a break in your consecutive service. All right. Co-owners in a residential condo that's more than 10 units can't serve as directors at the same time unless they own more than one unit or there aren't enough eligible candidates to fill vacancies on the board. We talked about acclamation. That's basically when there's not enough candidates to require an election. A quorum. There's no quorum requirement for your election, but at least 20% of the eligible voters need to cast a ballot in order to have a valid election. This is different from an HOA where you do need a quorum. In a condo, you do not. You just need 20% of the eligible voters to vote in order to have a valid election. Okay, the elections are decided basically by who gets the most votes. The official records include every piece of paper that is in any way relevant to this election. So ballots, sign-in sheets, voting proxies, everything is going to be kept, including envelopes, for 1 year from the date of the election, vote, or meeting. Okay, so, or until the next election if later. So you're going to maintain all of these records in a box or somewhere scanned in for at least a year, and then you can toss them. What you should be having, and this is one of, I think, 8 policies that my opinion is every community association should have, is a records retention policy that says how and when you're going to keep your records, when you're going to get rid of them, etc. We'll get deeper into this in a minute when we get to records, but make sure that you're deleting, tossing these records in accordance with that policy. Any challenge to the election. Now, keep in mind, this is not, well, this guy won and I don't like him. Someone files that in court, the judge should laugh them out of court. This is a challenge to the procedure. You either let someone onto the ballot that didn't belong there because they weren't eligible, you did something wrong in counting the ballots, etc. That is an election challenge, and it needs to be brought within 60 days after the election results are announced. Now, if you announce the result by counting the ballots 3 days after the election was supposed to be held, it's not 60 days after the election, it's 60 days after that result is announced. And if it's brought more than 60 days out, that judge should toss the case. Candidate is an eligible person who timely submitted that written notice of their intent to become a candidate, again, within that 40-day timeline. Anyone that wants to be a candidate must be eligible at the time that the deadline hits. So this is not as of the date of the election they need to be eligible. They need to be eligible that 40-day timeline before the annual meeting in order to be listed on the ballot or serve on the board. If you're delinquent in payment of any assessment due to the association, as of that deadline, you are not eligible. Now, I literally had yesterday a potential client group that I met with that was asking, what about fines? We think the association fined us for the specific purpose of making sure we couldn't sit on the board. Well, fines don't count in a condo, and they can't be converted to an assessment in a condo, according to Florida law. So those fines don't count. Those rekeying charges, unless they're treated as an assessment in your declaration, are not going to be something that can keep you off the board. The other thing, a person who's been suspended or removed by the division, the DBPR, under the Condominium Act is not eligible to be a candidate. Now, we'll talk about what some of those things are. I think Kerstin's going to touch on what reasons might exist to be suspended or removed by the division. If you've been convicted of a felony in Florida or something that would have been a felony if it occurred in Florida and haven't had your civil rights restored for at least 5 years, meaning you're 5 years out of prison, okay, as of the date that you seek election to the board, you are not eligible. Now, keep in mind also that if you didn't know about this because you're not performing background checks on all your candidates, which some communities do, some don't, it's not required. If you're not doing that, then anything that director decided to do before you figured this out, or if you never figure it out, it doesn't invalidate anything that the director did as a director. So the fact that they haven't had their civil rights restored for at least 5 years, not a reason to undo anything that's been done by the board while that person served. And then again, if a criminal charge is pending against an officer or director regarding association funds, forgery of ballots, theft or embezzlement, or obstruction of justice, meaning you didn't provide records because you were trying to avoid being caught in a crime, that person can't be appointed or elected as a director or officer of any association, and can't have access to the official records of the association, which the members are generally entitled to, except pursuant to a court order. So if you have these charges pending, and keep in mind, this is not John next door told the manager that he thinks this guy is stealing money from the association. There's actually a police file. There was a prosecutor willing to file what's called an information or indictment, meaning they're filing criminal charges against you, and it's been investigated. If you don't have all of that, then it's not going to keep you from serving on the board. It's only if there's an actual criminal investigation and criminal charges have been brought. Voting by secret ballot, you can't use a limited or general proxy in the election of board members. You use your ballot instead. Okay, and that ballot is technically supposed to be secret. It's cast using an inner envelope and outer envelope addressed to the person or entity authorized to receive the ballots. The way that we're going to do this is you have your ballot. There should only be one in each inner envelope. Okay, even if you're allowed to vote more than once, you should be putting those in the separate inner envelopes within the outer envelope and writing down all the addresses or all the unit numbers that you're voting for so that the association can verify that you have that amount of votes. The exterior of the inner envelope should be blank because that's for anonymity. Okay, the exterior of the outer envelope should say the name, signature, the name, the unit number being voted, and a signature of the voter. So basically, we're verifying that this person is voting. We don't know how because we have that outer envelope covering the inner envelope. And we're going to open these in order when we're going through the election process and counting the ballots. So we're going to have an independent group open the outer envelopes and separate out the inner envelopes without looking at what's in them. We're going to have that group then move all of those outer envelopes to the side after they've checked off that these people are actually eligible to vote. If you get more than one outer envelope from someone that doesn't own multiple units, meaning you get an extra outer envelope from someone, none of those ballots can be counted because you can't unilaterally decide which one to count. Okay, so those are going to be marked as disregard. You might put the reason on there. My recommendation is don't, because then if you disregard it, but there's another reason you could have disregarded it, but you don't write that down, the owner is going to argue that you should have let that ballot count and that your reasoning for disregarding might not be accurate. Okay, so we're going to write nothing other than disregarded. Now, once we've gone through all the outer envelopes and compared them to the member roster, made sure that everyone that is there is eligible to vote, we're going to take those inner envelopes, open them up, and take the ballots out, put them face down without looking, separate them out from the inner envelopes. a lot of people ask, well, what do we do with the ballots that weren't in an inner envelope, but were just in the outer, or that actually have the name or the address or something else marked on them so we can tell who voted? My perspective and the firm's perspective on that issue is let them vote. The goal is to be inclusive in deciding to let people vote when they want to. People don't show up for anything in condos and HOAs and co-ops. Okay, if they're going to show up and care enough to vote, let it happen. But the way that you let them vote is going to basically be to make sure that you're clear to everyone. If you put these markings on it, if you've done this, we consider it you're waiving your anonymity as to how you voted. We're still going to count your ballot. All right. Oh, and if the inner envelopes contain more than one ballot, you're also going to invalidate them regardless of how many votes the person had, because you can't tell whose ballots they were anymore now that you've separated them from the outer envelopes. So you're going to, again, mark disregard on that envelope without even opening it. And if you open it and there are more than one, you're going to put disregard on both of those ballots. And that one, you might want to keep track of the reasons. Let's see. We talked about this. Can't rescind a ballot once it's received. So keep in mind, once you submit that ballot, that's your vote. You're done. You can't authorize someone else to vote on your behalf. Any ballots improperly cast are invalid. A unit owner who violates that provision can actually be fined by the association. So you need to vote through your own ballot. All of these are essentially mail-in. So there's no reason that you have to give your ballot to somebody else. If you need help in casting the ballot because you've got some kind of disability, then you can get assistance in the manner required to enable you to vote. We talked about voting the outer envelopes. You can do this at a separate meeting so that your actual election doesn't take quite as long. Okay, but that needs to be done by a meeting of an impartial committee consisting of people who aren't directors, officers, candidates, or spouses of those people. And they will compare what is on the outer envelopes to the actual roster that you have for your membership and decide who gets to vote and who doesn't, based on whatever criteria you're using. Any outer envelope that's not signed must be marked disregarded as well. So if it's not signed, you can't tell that that person actually submitted that ballot. So make sure that everyone in your community is aware if they want their ballot to be counted, they need to fill out all three things: name, unit number, signature. All right. Anyone who engages in fraudulent voting activities related to elections, if you don't know what they are, God help you, commits a first-degree misdemeanor. Forgery of a ballot envelope or a voting certificate used in a condo election is punishable by a third-degree felony. So forgery in an election is a third-degree felony. Voter fraud, meaning threats, bribery, intimidation, that's going to be a first-degree misdemeanor. Bottom line, don't commit crimes. Pretty straightforward. Electronic voting is a great thing. I'm not going to go through it in detail, but I will explain what it is. It's essentially where everyone gets to vote either via an app, a website, or something similar instead of having to submit a paper ballot. This can be extremely useful, especially when you've got people that are investors and don't live in the community, especially those that live overseas. They might need to use a VPN to actually access the vote. But the reality is, this will enable a lot of people who've been ignoring your elections to actually vote going forward, because it enables them to not have to check the mail, which they usually don't do, to not have to tell you where their mailing address is, as long as they're giving you their email address one time to send that information to. They do need to opt in. The association needs to adopt an actual resolution authorizing electronic voting. You have to have a vendor. It's not just sending an email to vote, at least not yet. I think the legislature is trying to push that one through. But as of now, you need to have an actual vendor in order to vote electronically on anything that is an association member vote. So again, you need a resolution, you need a vendor, you need people to actually opt in. Otherwise, you have to still send them all the documents by mail. That opt-in can be done electronically in and of itself. And the other thing to keep in mind is I mentioned earlier the ability to have people receive electronic notices instead of mailing them. This is another way of getting people to opt into that email. So just something to keep in mind. The officers. Now, we don't spend a lot of time talking about the different hats you might wear in your community, but I'm going to do it real quick now. There are members of the association. These are literally the owners. Okay, so you probably, if you're here, you're probably a member of your association. You might also be a resident. That just means you live there. Tenant, same thing. It's a resident that doesn't own there, not a member, but they have certain rights in the community, much less than what a member would have. Then you've got your directors. That's your board. These are the people that actually vote on things other than the things members get to vote on. So I'd say 70 to 75% of every decision that's going to be made by your condo or co-op is made by the board. These are important people, and they need to treat this as an important job because in reality, they are running a business even if they don't realize it. That's probably the most important thing we can teach you today. You need to make decisions like you're running a business because you are. You'll notice the name of the corporation that's in the declaration is probably a not-for-profit corporation in Florida. When you do business, when you make decisions for the association as a board, you're running that business. So the directors are basically the people that make motions, second them, vote on them, or abstain from voting if there's a conflict of interest. I hate when people abstain because they don't like the options. Okay, that's not your prerogative. Your prerogative as a director is to say yes or no. If you don't like the options, say no. Okay, but at least let your voice be heard. You were elected or appointed to do your job, so please do it. Then finally, we're at the officers slide. The officers are the people that are designated in the bylaws usually to do certain tasks. Now, if you've got a qualified manager that is actually contracted to do the work that most management firms will do, those officers don't really have a whole lot to do other than make decisions in their separate capacity as directors. So you've got your president, that's going to be the mouthpiece, the person that signs all the documents on behalf of the association, etc. They preside over the meetings if they're there. So that's how that's generally going to work. Then you've got your vice president who really doesn't have to do anything unless the president's out, and then they take over the president's spot. So that's a let's pray that the president's always there. That's your whole job there. Um, You've got your secretary who the manager is probably doing most of that work, which is keeping the records, keeping the meeting minutes, keeping everything organized, etc. And then you've got your treasurer who handles the money, which your manager is probably also going to be doing. So there's nothing that says that you have to keep the officers that were initially elected for the course of the entire year. You can switch those at any time. So a lot of times when a director or an officer is going rogue and making their own decisions regardless of what the board wants to do, or they're reaching out to owners independently and frankly screwing up potential litigation and getting the association in trouble, you can take them off as the president and say, you are no longer an officer. You have no independent authority to speak on behalf of the association. All you're allowed to do is attend board meetings and vote at them and make motions and second them during those meetings. So that is generally how we handle. You can't simply remove someone from the board without a recall, which Kerstin will get into later, but you can take them off of their officer position at any board meeting where that item's on the agenda. All right. Directors and officers generally serve without compensation. And at the officers, it's at the pleasure of the board, meaning they can be replaced at any time. That is, unless the bylaws say otherwise, and they're generally selected during that organizational meeting following the election of the directors. Disqualification, if you accept kickbacks. If you don't know what a kickback is, you haven't been paying attention to Miami lately. Well, I say lately, really about 8-9 years ago. I haven't seen as nearly as much of it going on lately. But you commit a third-degree felony and you're subject to civil penalties as well and need to be removed from office and a vacancy declared if you are found, and again, this is information or indictment, but you're found to have accepted a kickback. That's literally anything of value that you didn't pay for your own benefit or that of your family, from anyone that proposes to do business with the association. Perfect example, you're having the outside of the buildings painted at your condo. You wanted to do your repainting internally and you hire the vendor, but you didn't hire them. They just agreed to do your unit internally, and it's not an association responsibility to do that repainting internally because you were going to sign that $200,000-$300,000 paint contract, or they're offering to do it at a discount because you're doing this. Now, if everyone in the community gets that discount, totally fine. If everyone in the community gets it done completely free, totally fine. But if you're benefiting in a way that not everyone in the community is benefiting by virtue of your position on the board or your officer position, that's a kickback and it's not allowed and it's a third-degree felony. Again, criminal charges, don't do it. If you're more than 90 days delinquent in payment of any monetary obligation. Now, we talked earlier about assessments. Okay. You couldn't be on the board if you owed any assessments. This is you're off the board once you were on if you become more than 90 days delinquent in the payment of any monetary obligation. So if you want to waive those fines, you better make sure they get waived within the first 90 days after you get elected, because otherwise those fines will be enough to pull you off the board. If you knowingly and willingly violate the official records inspection requirements 2 or more times within a 12-month period, that's a second-degree misdemeanor, meaning you are choosing not to provide records on purpose. Anyone that knowingly and intentionally defaces or destroys accounting records that must be maintained during the period that they need to be maintained, or fails to create or maintain those records with the intent of causing harm. Now, I say with the intent of causing harm. That is not just, well, you didn't do it. It's you're trying to hurt the association or a member. That is a first-degree misdemeanor. Also, civil penalties also get off the board. And then finally, if you knowingly and willingly refuse to release or otherwise produce records, that is a third-degree felony. It's generally going to be considered obstruction of justice if it's done in furtherance of another crime. So this is intent to avoid or escape detection. Okay. Oh, I'm sorry, I missed this one. Using a debit card issued in an association name or billed directly to the association for anything other than a lawful obligation to the association, that is theft. Okay, it's not, but according to the law, it is. So if you use a debit card, cut that thing up, at least if it's in the association's name or billed directly to the association. What I want you to do instead, use your own debit card and be reimbursed, or get an association credit card. Okay. For some reason, it's debit cards alone. And I think that's because the money comes out pretty much immediately. That's why the legislature decided that this was more crucial. But if you use this debit card, it is not something, it is a crime. The amount of the crime is generally going to be the amount that you used. So whether it's petty theft or something else is, I don't recall whether the HOA or condo statute changed that last year, but one of them, and I think it's condo, it actually says that the amount of the theft is determined by the amount that you spent. So if you go out and buy $5,000 worth of materials at Home Depot, even though they were from the association, if you didn't get, and this is what lawful obligation of the association means, if you didn't get pre-approval by the board and meeting minutes reflecting that approval, then you've committed that theft. Even though it was 100% innocuous and intended for the association, you can still be charged with a crime. So bottom line, don't use a debit card. If you violate conflict of interest requirements, you are off the board. And if you fail to timely file the written certificate that you'll get from this class within 90 days after being elected or appointed to the board, and I think Kerstin goes through that one as well, you are technically off the board. All right, websites. I said it was Kerstin. I guess I'm doing this one. But basically, as of now, if you have 150 or more units that you're responsible for, you needed to have a website in 2019, effective January 1st of next year. Basically, by the end of 2025, if you have 25 or more units, you need to have a website. Now, I'm not going to go through a lot of this because it's basically something that if you've got a manager, which most condos in Florida do, they're probably taking care of it. If I'm not going through this and you need guidance on it because you don't have a manager, feel free to reach out to me and I'll be happy to walk you through it. Or read the slides and you'll probably get the same information you get from me. But bottom line, it needs to be password protected web portal or website that's wholly owned and operated by the association or by a third-party provider, and you need to own the rights to operate that page under that third-party contract. The website needs to be accessible through the internet, needs to have a subpage or protected electronic location that the general public can't access with username and password login credentials. All management firms that do this service will provide those login credentials already. Current copy of the following documents need to be posted on the website. Won't go through them because you can read just as well as I can read. So that's also a good way of saving some time. The one important one that I will mention, notice of any board meeting or member meeting does need to be posted on the website if you're required to have one. If it's a member meeting, you need to post it 14 days in advance of the meeting with the agenda. Within 7 days before the meeting, all documents that you might vote on also need to be posted on the website. So if you've got amendments coming up, you've got a contract that for some reason the members get to vote on, things of that nature, any member vote, you need to have whatever documents you're voting on uploaded to that website and accessible to the members at least 7 days before that meeting. If you're talking about a board meeting, it's generally going to be 48 hours in advance that you have your meeting notice, your agenda, and any documents that you're going to vote on posted on the website. If you're talking about a meeting that is to vote on assessments, special assessments in particular, or where you're voting on changes to rules regulating unit use, that's a 14-day notice with 7 days, just like a member meeting. Okay, so 14 and 7 for members, member meetings, assessment meetings, or rule meetings, 48 hours for all other board meetings. Let's see. From my perspective, the easiest way to do this is to just upload all of the official records in an organized fashion to the website, because you're required to produce them, and you can produce them by simply saying, go to the website, they're all accessible. So it can save you a lot of time and money to have your policy be that, an appropriate response. And this is another policy number 2 that I'd recommend all communities have, is a records inspection policy. And that policy in a condo can say, our response to every records inspection request will be go to the website, because we upload everything there. Everyone needs to designate a person or entity where you can serve those requests and where you can request estoppel certificates. That's important. All the meeting notices also need to be posted on a separate page on the front. So that can either be directly on the front page of your website or on a link that's directly on the front page of your website. That's really the big difference between what management firms are already providing through the portal and what the statute now requires. I believe that the systems that Empire uses will allow them to do this for you, even though it's just through a pop-up or something similar, to have that front page include the link. You can use a mobile app instead. And now we move on to official records, because we've got 40 minutes-ish until we get to the end of my time with you all today. And because we've got limited time, the official records are basically the documents and pieces of paper and other written materials that the association needs to keep. Now, I won't go through what they are. Here's why. This number 19 right here is a catch-all. All other written records not specifically included in the statute that relate to the operation of the association. What does that mean? Everything that's written that pertains to association operations is an official record and needs to be maintained in the official records. Okay, so that's why it's not really even worth going through this entire list. Again, you'll get a copy of it once you complete everything at the end of the webinar today. But keep in mind, again, all the written records pertaining to the association are things that you need to maintain. Now, here's the time frames that should be included, not only in the statute, but in your records retention policy that I mentioned earlier. Okay, so these are most records need to be maintained for 7 years. However, permits, plans, warranties, and other items provided by the developer are kept indefinitely. What you're supposed to do about that if you destroyed them 50 years ago, I have no idea. Technically, I think you're supposed to be trying to find copies, even though they might not exist. Copy of the recorded declaration, bylaws, and all amendments. That's something that we provide as step 1 in working with any new community. So if you don't already have those and you want to work with us, or you're working with us, you should have them already. But step 1, we pull a title search and we search the official records of the county and pull and compile the entire set of governing documents, along with the articles of incorporation and amendments. And then you should have copies of all current rules, all meeting minutes. So all of these are kept forever. Now, when I say forever, it says current rules, not all rules that have ever existed. So technically, only the current iteration is what you need to keep. We mentioned earlier the CEUs and inspection reports you're keeping for 15 years. We mentioned the election records for 1 year. The other one that's for 1 year is bids for work to be performed or materials, equipment, services. So that is, any bids or basically any documentation saying we'd like to work with you. That doesn't necessarily include contracts that you get from an attorney saying, well, we'd be willing to work with you under these circumstances. It's primarily bids in particular that you're going to maintain for that 1 year period. Now, after all these time frames elapse, technically you can get rid of these documents. You have no obligation to maintain them any longer. But you need to have, in my opinion, a records retention policy that dictates when you're allowed to get rid of these records. Because otherwise, I know some people will just kind of do it whenever they feel like it, and the likelihood that you make a mistake is significantly greater. And we want to avoid mistakes. I know that sounds crazy, but that's what we try to do here. Okay, the official records need to be maintained, and this changed last year in a very obnoxious way. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. So you may have been told in the past, yeah, we're gonna mess with this guy. He wants to inspect the records. He's being a pain. We're just gonna bring 40 boxes of crap out and tell him, hey, good luck, have a nice day. We'll be, you got 8 hours to inspect whatever you want. Unfortunately, that is no longer an option. It's fortunate for the owners. It's fortunate for your attorney who needs these records sometimes to deal with disputes, but it is something that is now required by Florida law that you maintain them in an organized manner that facilitates inspection. Meaning, if you've got categories of documents you're obligated to maintain, my recommendation is maintain them in those categories so that if anyone wants to see the financials, okay, here's the folder. Have a nice day. Not here's the folder, but our records are online under that folder. Go on your portal, buy. And this is what I mentioned earlier. If the records are lost or destroyed or otherwise unavailable, or the obligation to maintain them, then the obligation to maintain them includes a good faith obligation to obtain and recover those records if reasonably possible. So if you have an obligation to maintain certain records permanently and they're gone, you have to now go out and find them somehow. If you can't find them, you just got to show that you did your due diligence. Okay, inspection and copying within 10 business days after receiving a written request by the board or its designee. The official records must be made available to the owner and the owner's authorized representative. Okay, so this is an inspection. Any member has the right to inspect your official records with limitations that we'll get into in a minute. Okay, but any written request, again, doesn't have to be certified mail return receipt requested, doesn't have to be sent even in the mail unless you have a written policy that requires that. Now we talk about and the owner's authorized representative. It used to be or. Now an owner can bring their attorney. They can bring John Smith down the road who would do a better job of reviewing the records. It doesn't matter as long as they've designated this person to do the inspection with them as an authorized representative. Both people can now show up at the meeting. Now that meeting needs to be held within 45 miles of the condo or in the county where the condo is located within those 10 business days. And it is not send a response within 10 business days for an inspection to be done 20 days later. You need to actually provide the records for the inspection within those 10 business days. Renters have a separate right. They're very limited in what they're allowed to inspect. It's really only the governing documents and the inspection reports. They don't get access to anything else, but they do have a right to do that inspection. You can comply by having a copy available. Like I mentioned earlier, you've got your boxes, but now they're organized. You can offer the option of making the records available electronically, meaning you're sending them via the website or directing the owner to the website. Or you can allow them to be viewed in electronic format on a computer screen within the association office or within that 45 miles or within the county, and allow them to print on request. The right to inspect includes the right to make copies or obtain those copies at a reasonable expense of the member. Now, the first 25 copies are free. If you have a policy or your management agreement says that you're going to charge for copies, you can charge up to, I think it's 25 cents per page for anything over the first 25 pages. Excuse me, I need a sip. You need to allow the member or their authorized representative to scan things for free or make an electronic copy of the records in lieu of providing copies. So in other words, they can bring their iPad and take pictures of everything they want. You need to maintain an adequate number of copies of the governing documents and certain other documents. I have no idea what an adequate number of copies is. That's pretty arbitrary and decided by who the hell knows, probably a judge at some point. But bottom line, if you're providing these records online, then the amount of copies you have is infinite, and I wouldn't worry about it. So again, I've been pushing clients towards maintaining these records electronically for over a decade. The legislature has now codified that that's okay. You do also need this new checklist effective July 1st, 2024 of everything that you provided and everything you didn't provide as part of the inspection process for each inspection that's requested. That checklist needs to be maintained for 7 years after that inspection. It needs to identify any records that weren't made available. My perspective is we've actually created a form. We haven't had anyone come back and say that's not good enough yet. But until we do, my perspective is you only need a list of the categories that were allowed and were not allowed. So that form can be used by pretty much any community. We do charge for providing it, but it's something that from my perspective, you don't need to sit there and write down every single document that was provided and every single document that wasn't. It's the categories of documents from my perspective that are included in the statute, and it's almost a copy and paste. You can have rules governing the frequency, meaning not more than once per month, the time, meaning how long you have, no less than 8 hours per month, the location where this inspection is going to be done within that 45 miles or within the county, the notice, and the manner of the records inspection and copying. But you can't require an owner to show a proper purpose or any reason that they want to perform the inspection. They have an absolute right as members of the community to perform that inspection. Now, here's a whole list of items that are not accessible to members and that shouldn't be on your website as a result either. Okay, unless it's behind a separate set of login credentials that only the board and management get to access. It'd be great if people gave access to the attorneys as well, but they don't tend to do that. That way we could just search for the things we need instead of saying, hey, please give me, these categories, almost like we're doing a records inspection. But anyway, I won't go through the major list because we're running shorter on time. But the bottom line is this is an enormous list of things that you get to not produce to the members. It's things that you're basically protecting the association's privileges or protecting private information of individuals who gave that private information to you. One of the important ones that I'll mention is attorney-client privilege materials do not get disclosed unless the board as a whole, not just an individual director or the manager, but the board as a whole decides we're going to disclose that. Your attorney can't even disclose attorney-client privileged information unless the board authorizes it. So no individual director should be ignoring that privilege and providing that information to the members. Medical records are another one that's important, personnel records, or personal information. Now, I'm not going to go through again in detail, but you've got a laundry list of items that you're not supposed to be providing. And when I say not supposed to be, I really mean you don't have to provide to the members and frankly shouldn't provide to the members because they are protected information. Let's see. An owner can consent to giving away their personal information. Again, you don't post these items on the website accessible to all of your members if it's something that you're not supposed to be disclosing. Inadvertent disclosure is not ideal, but unless it's a knowing or intentional disregard, it's kind of a no harm, no foul. You won't be held liable or shouldn't be held liable for disclosing information that should have been removed or redacted, unless it was knowing or intentional. And the association, fortunately, is not responsible for the use or misuse of information someone gets as part of this inspection unless you had an affirmative duty not to disclose that information. So if someone asks for your member roster, yes, you have some limitations that you can impose. You're not going to provide certain information about how to contact people, but you do have an obligation to say, here's their mailing address, here's their name, here's the unit address, certain other information like phone numbers and email addresses might be included. you're not responsible as an association for providing everyone's information to this person who then decides to use it for nefarious purposes. Attorney-client privilege we went through. Failure to timely provide access. I call it the $500 gift, and it's not a gift you want to give. This is failure to provide access within the 10 business days that I mentioned, and that's 10 business days after you receive the written request. That's a rebuttable presumption that you did not comply on purpose. It was a willful failure to comply, meaning you intentionally didn't give these records to this owner to inspect and copy. Now, if they are denied the right to do this, is entitled to actual damages. I'll be honest, I've never seen actual damages in a failure to provide inspection type of case, but I've seen plenty of cases where the minimum damages were given. And that is, if you do not comply and it is found to be willful, whether it was actually intentional or not, the owner is entitled to damages plus their attorney's fees and costs. And those damages, the minimum damages is $50 a day, starting on business day 11 up through business day 20 for every business day that you failed to produce the records. So you're talking about up to $500 plus fees and costs. Anyone that is, I'm sorry, that fees and costs is already addressed. Failing, we talked about to provide these records twice or more in a 12-month period with intent to do so means that you are committing a second-degree misdemeanor and you're removed from office. And refusal to allow the inspection and furtherance of a crime is basically obstruction of justice, which is a crime in and of itself. Anyone who knowingly or intentionally defaces or destroys accounting records that need to be maintained, or knowingly or willfully fails to create or maintain those records. We talked about some of this. First-degree misdemeanor. Personally subject to civil penalties, removed from office. If you fail to release the records intending to escape detection, that is a third-degree felony and must be removed from office as well. Destruction of official records in furtherance of any crime is punishable as tampering with physical evidence or obstruction of justice. We've talked about a lot of crimes already today. I want you to understand, these are not things that the police are taking lightly and just trusting when owners report that you've done these things. There needs to be some proof. So don't sit here and freak out. Alan's talking about all these crimes. You know, he wants us to get off the board. He thinks it's a thankless job. I do think it's a thankless job, and I think there is some risk. Fortunately, Kerstin's going to talk about directors and officers' liability insurance. And if you can avoid being prosecuted from a crime, there's very little that you can do that's actually going to be inadvertent, that's going to actually get you in trouble. Most of what you would need to do is going to be 100% intentional with the intent of hurting someone other than yourself or benefiting yourself to the detriment of others. That's going to get you in trouble. Most of what you might do inadvertently, there's protections for. But that directors and officers liability insurance policy, I always joke, that's your third most important bill that you'll ever see, because that's what protects the individuals on the board and the officers from personal liability. You have an insurance policy that covers it. If you don't have that, get it now. And again, I joke that it's the third most important, but in reality, I think it is. Your manager's most important, your lawyer's second, and that bill is third. If you don't pay those three people, you're going to be in a hell of a lot of trouble. Okay, anyway, an outgoing board or committee member needs to give up all records and property of the association within 5 days after the election. So if you come off the board, you hand every association property, every piece of association property back over to the board within 5 days. If you don't, then you can be sued personally, and that is an intentional act unless there's a hurricane going on during that time frame or something like that. If you willfully and knowingly fail to give up association records and property, civil penalties imposed by the division as well. So you can be sued by the association and you can be punished by the DBPR. Don't do it. Now, great news, everyone. You don't have to listen to me anymore other than the Q&A, because topic 2 and topic 1 are now complete. I will go through, Jeff, I'll let you do your thing for a minute, and then we'll get into as much Q&A as I can get to while we have, a lot of time left. And then I will drop off shortly before 1 o'clock so that Kerstin can take over and kick some butt with topics 3 and 4.
Sounds great. Well done. Well done, Alan. Just a reminder for those of you who may have joined slightly after I did the introductions, open the chat area, click the chat button simply so it appears, not to be confused with the Q&A module, the two different things. So press the chat button once so it shows up on your Zoom interface. It will say chat is disabled. There is nothing for you to enable. We can still send information your way. That later on is where we're going to place the link to click on to get to the required evaluation that you fill out at the end. Okay, please adhere to that because the evaluation is required. We cross-check that with the attendance sheets to make sure that everybody attended in full before we send out your certificates via email. So again, hit that chat button one time so it appears. And to answer a few of you that have been asking, yes, these slides will be available and it will be after you fill out that evaluation later on. So you'll fill out the evaluation, you'll get a confirmation screen showing a successful submission. That confirmation screen will have the link for the slides as well as everybody's contact information, Alan, Kerstin, and the fine folks over at Empire Management. John, do we need to leave the chat session open? Yes. Once you hit the button to open the chat area, just leave it there. Just leave it open because you will only see what we place in there after it has been opened. If we put something in there now and then you first open the chat later, you will not see it. I'll place the link in there more than once. Don't worry, but just be ready now. Have the chat area open and just leave it open. Alan, back to you, sir.
All right. Well, good news, bad news. There are not a lot of questions in here, so I'm going to go ahead and fire through them. And
because you were so dang clear on everything.
Well, maybe not, because the first one I definitely addressed, and there's still a question. So we'll see in a minute. Pamela asks, my board members have served 8 years or more. Please explain. Well, I can't explain what your board members are doing, but I can clarify what the law requires them to do. So keep in mind, as I mentioned, the law that says you can only serve for 8 years kicked in July 1st, 2018. And that means that it doesn't impact anyone's service or require them to come off the board until July 1st, 2026. So if they've already served for 8 years and they stay on until that time, then technically it would be July 1st, 2026 that they need to drop off the board. So what you're suggesting is still legal in the state of Florida. It's not a problem. It may not be ideal for you or the other members of your community. I can't speak to what community you're in or how they're doing, but the bottom line is serving 8 years or more is not yet problematic because that timeline doesn't take effect, and the requirement that you drop off and can't serve consecutively doesn't kick in until July 1st, 2026. Dominic asks, has the governor signed off on the latest legislation for 2025? As I mentioned earlier, this one as well. There has been a signature by the governor on House Bill 913. So again, we'll probably be having a webinar sometime in mid to late July, and it might even be the same people you're talking to today, having that webinar regarding some of the changes that'll take effect on, or will have taken effect on July 1st because of that legislature having been adopted by the Florida government. Dominic asks as well, what's happening with the idea of email for voting purposes, which may become mandatory. Craziness is what's happening, and we'll talk a little bit more about that during the webinar I just mentioned. Veronica, thank you for your kind comment. Jerry asks, if all units are owned by owners to outside walls and finished roof, oh, okay, the outside walls and the finished roof are part of the units, I think is what you're saying. Does the milestone inspection apply to 3-story units? So I'm not sure what any of that means, but 3-story units are distinct from 3-story buildings, which is what we're talking about. So if your building is 3 stories or more, regardless of what the units are comprised of, you'll need to have that milestone inspection done. You'll also need to have the structural integrity reserve study done. What that study is comprised of and who pays for it will be determined by what is considered part of the unit versus part of the association maintenance obligation pursuant to the declaration. So I think that's probably the issue that you're looking at. As of right now, there's nothing that says you have to have parts of the unit inspected. It's the outside. Do we have an article on good corporate governance? Philip asks. an article highlighting the role of the board versus the role of the officers. If you have them, please email them. Philip, I'd suggest you actually go on our website. We've got some fantastic articles that are written by various different people within the firm, but Rembaum's Roundup has several articles, I think, on some of these topics. And I know that Robert Kay and some of the other attorneys within the office have also written about some of those topics. So I would suggest you run a search on both of those portions of our website and see if you can find anything. Yvette, do these rules apply for condo commercial one story? Again, any commercial, it won't apply. Any one story, it won't apply. So it sounds like, Yvette, the answer is no. Perfect. Alejandro asks, in a records request, can the member request to see all non-privileged email communications between management and the board? Well, if they're specifically saying non-privileged, then potentially. This is one of those that could go either way. The DBPR has decided in both directions multiple times as to whether these emails are considered written records of the association and need to be added to the official records. My suggestion is once it's printed, once it's been, attached to something, it becomes a written record. Kerstin, you may have something to add there, but from my understanding, there have been DBPR opinions in both directions as to whether emails between directors or with management actually qualify as official records of the association that need to be produced. And you are on mute in case you choose to answer, but that's up to you.
No, I agree with you, Alan. I think the latest is that the division would consider those email communications as part of the official records.
All right. Let's see. So I touched that one. Mike asks if a condo unit is 2.5 stories, 2 stories with a loft in the attic space, is it considered 3 stories? Well, then you're going to go to the Florida Building Code to determine whether that half story is considered a story according to the Florida Building Code, which is really the definition we're looking at. So if that half story is not considered a story under the Florida Building Code, the answer is you probably wouldn't need the milestone inspection or the structural integrity reserve study. If the Florida Building Code says, yeah, this definition, this loft in the attic space, the attic space itself is considered a 3rd story, then yes, you'd probably need it. You'd be subject to these requirements. Okay, Linda, too much info, very overwhelming. Glad I have a great management company. Very happy for you. Yeah, it is a lot of information. They give us 8 hours of information to share in 4 hours, and we try and condense it even further. So, there's a lot.
As we like to
Anna,
say, don't shoot the messenger. We're told to do this.
yeah, I mean that when the legislature adds 5 topics of what needs to be talked about throughout this presentation, just understand we need to comply. Otherwise, you won't get credit for the class and we won't be able to provide credit for it. So, Anna, you mentioned something that doesn't apply to 2-story units and I missed it. Can you clarify, please? 2 stories are not required to comply with milestone inspection requirements or SIRS requirements. Jerry, we have 12 units, but only 3 board members due to lack of participation. Are we out of compliance? Probably not, but it depends what your governing documents say. What I would suggest is if you can appoint 2 more directors, do it. But I mean, you need to have at least 5 according to law. Your bylaws probably require that as well, but I've never heard of an association getting in trouble for having 3 instead. I don't even know what someone would report or sue for in that instance. So my perspective is if you can get another 2 to serve, great, do it. If you can't, there you go. But at least if you try and you even put out a communication to the entire community, then you've made every reasonable effort. And anyone that tries to come after you for not having enough directors, especially someone that's not willing to serve on the board, shouldn't have the right to say anything about what you're doing or not doing. Okay. Do attics count as a floor? Well, we just addressed that, and Mike's question addresses the same thing. So we'll move on. Let's see. If money's spent, Doug asked, if money is spent from the reserve fund, must it be replaced in the following assessment? That's going to be up to your reserve analyst or your architect or engineer to get you an updated study once you've spent that money on whatever that asset was. So generally speaking, if you used it for something else, it's up to how you voted as to whether you replace those funds next year. I would recommend you do, but it's going to be up to the members. If it's something that you use the money because that asset actually required it, then no, you're not immediately required to replace the funds because presumably you've already incorporated that maintenance or you've updated your reserve amounts going forward to account for that over the estimated useful life of that asset. And Kerstin will get into more of that later. Let's see. Yeah, it doesn't matter how many buildings you have. If you're less than 3 stories, you don't need to do this. Milestone inspections and serves. Terry, so you're saying if a debit card's used by a board to pay for something, that use must be approved by all board members? No, I'm saying that there needs to have been a vote and meeting minutes to approve it, or it needs to have been included directly in the budget of the association. If a board member pays for a service with their own cash to be paid back later, does that need a vote to be approved? I would say yes, most likely, because otherwise, how is it authorized to reimburse that person if no one voted on it? George, thank you for your comment. John, I believe the SERS requirement applies to buildings 3 stories or more, not depending on individual unit floors, right? Yeah, it depends under the Florida Building Code whether it's 3 stories or more. Unfortunately, I can't be any more clear than that. And then finally, David asks, at our recent election, the management company limited the number of candidates to vote for. Is this compliant? Well, that depends whether there was anyone else that was actually eligible to serve on the board and whether they actually submitted their notice of intent to be a candidate. If there wasn't anyone else that was eligible to serve and that submitted their notice of intent, they couldn't be listed on that election ballot. And so management would have done the right thing. All right. Well, Jeff, I'll leave up to you whether to disable the Q&A or leave it open, but we're cutting off this session, so to speak, for Kerstin later. But that's all I've got. I want to thank again Empire and Kerstin especially for taking over the second half, because if you guys had to listen to me for another 2 hours and I had to try and speak without taking a drink for another 2 hours, I might not make it through. So Kerstin, my friend, thank you very much. Jeff, thanks as always for your help. And again, Empire, love working with you guys. Thank you so much for co-hosting with us and especially having the top dog show up. Jose, always appreciated, my friend.
Thank
Happy
you,
to help,
Alan.
my friend. Thank you.
All right. Thank you, guys. I'm going to drop off because I have another meeting at 1 o'clock and I would like to get a little bit of water before I do. So thank you again. I hope the second half goes even better than the first. Kerstin, I'll pray for you.
Thanks, Alan. Bye.
See you, Alan.
Thanks, guys.
All right. Let me share my screen. All right. Are you seeing that, Jeff?
Yeah, we're good to go.
Okay. All right. So I'm going to cover topics 3 and 4. For those of you who got on the webinar a little bit late, my name is Kerstin Henze, and I'm a partner and managing attorney of the West Coast office for the firm, which is located in Tampa. So let's go on with topic 3. All right. Transfer fees and estoppel certificates. Just make adjustments here. All right. So transfer fees. This will come up if you have the ability to approve or disapprove certain types of transfers, including leases, sales, and other types of conveyances, which could include conveyances by quitclaim deeds. Those are typically considered gift transactions. But in order for you to be able to charge a transfer fee, or also referred to as an application fee, you have to have specific authority in your governing document, specifically your declaration or the bylaws. Okay. Now, it's not enough that you just have the authority to approve or disapprove these types of transactions. You actually have to have verbiage in your declaration or bylaws that authorizes you to charge this particular fee. Now, currently, the statute allows the association to charge a fee not exceeding $150 per applicant, other than husband and wife or parent-dependent child, which are considered one applicant. So as a practical tip, whenever a client asks us to add this authority in the governing documents, by way of an amendment, the way we would draft the amendment, the way we recommend that you do it, is rather than including the exact amount that you can charge currently under the statute, we would recommend that you draft it, that you draft the amendment to just give the board the ability or the authority to charge this fee up to the maximum amount allowed by law, as amended from time to time. This way, if the statute should change, well, the amendment automatically will incorporate any changes to the statute without having to amend this provision in the future. Now, if we're talking about leases, if the lease or a sublease is a renewal of an existing lease with the same lessee or sublessee, then the association cannot charge an additional application fee or transfer fee. Now, the application or transfer fee, what it's supposed to cover is the background check that typically management or board will do on the applicant. So it would cover the fee to do the background criminal check, and then as well as a credit check. Now, in addition to the transfer application fee, if authorized in the declaration or the bylaws, the association can also require a tenant to pay a security deposit. Now, the security deposit cannot exceed the equivalent of 1 month's rent, and it's typically whatever the prevailing rent is in your community. And that security deposit will then be held in escrow by the association. Now, it's important to know that the security deposit is only intended to cover damage to the common elements or association property, obviously caused by the tenant or any family members or guests of the tenant. It is not intended to cover outstanding delinquent assessments from the owner or to pay for any fines that you may have imposed against the owner or the tenant or any other charges. Okay, it's only to cover damage to common elements or association property. And then once the tenant moves out, vacates the unit, the refund of this security deposit would be handled in accordance with Chapter 83 of the Florida statute, which is the landlord-tenant statute. So there are certain notice requirements that you would have to give the tenant if you're going to keep any portion of that security deposit to pay for any damage. All right, so moving on to estoppel certificates. So estoppel certificates will come into play when a unit owner is looking to sell their unit, right? For those of you who have repurchased your unit in the condominium, you know that typically there's a title company involved in the sale purchase transaction. And one of the roles of this title company is to make sure that the buyer gets clear title of their unit, right? And one of the ways that they do that is, among many other ways, they will contact the association to confirm certain information, specifically, what outstanding amounts are owed on the unit, right? And that is done through this process. Okay, through this estoppel certificate. Now, what the statute currently provides is that within 10 business days of the association receiving a request for an estoppel, you have to provide a response. Okay, you have to provide this estoppel certificate. Now, the association has to designate on its website the person or the entity with the street or email address of receipt of the estoppel certificate request. Now, the estoppel certificate must be completed by either a board member, authorized agent, or authorized representative of the association, which may include your property manager as well as your legal counsel. The estoppel certificates have to be provided by hand delivery, regular mail, or email. And then the estoppel certificates have to be signed by an officer or an authorized agent of the association. Now, in the next few slides, I've included essentially what information the association has to include in these estoppel certificates. Now, this information comes straight from the statute, so you don't have to recreate the wheel. you can just basically copy and paste this information to create your own estoppel certificate. So some of the general information that you will identify on your certificate will include the date of issuance, name of the owner, property designation or address, any parking or garage space numbers that correspond to the unit, attorney's name and contact information if you have any, the fee for preparing this estoppel certificate, name of the requesting party. And then the estoppel certificate will go into more detailed information. So there's a section that's going to pertain exclusively to assessments. So among the information that you'll need to provide is the amount of regular periodic assessments levied against the property. That refers to your monthly or your quarterly assessments, the date that your regular periodic assessment is paid through, the date of the next installment of your regular assessment. You'll have to itemize a list of all assessments, including any special assessments and any other monies that are owed on the date of issuance. So if the unit being sold is delinquent to the association, that now is the opportunity for you to identify all sums that are owed to the association, and that would include any late assessments, any administrative late fees, interest, any attorney's fees that you've incurred in collection matters. And then there's some additional information that you will want to also reflect on the estoppel. For example, if there is a capital contribution, resale, or any transfer fees that are due, you'll identify that. Importantly here, number 2, are there any open violations of any rules or regulations previously noticed to the owner of the property in the official record? So, for example, if an owner is in violation of any specific covenant or rule, for example, if an owner has undertaken an unauthorized alteration of their unit, okay, they did something to the unit, to the exterior of the unit they were not supposed to do. You've noticed this owner, you've given them notice of the violation, and this the selling owner hasn't corrected the violation. Well, you will want to reflect that violation on the estoppel certificate. And the reason it's important that you do that is because if you don't reflect the violation on the certificate and the unit sells, well, the next time you go and approach the new owner to correct that existing violation, well, that owner now, the new owner will now have the defense of waiver, okay? And they could raise the defense and say essentially, well, you should have put the violation on the estoppel certificate. You failed to do that. So you didn't notify me as the new owner of the violation. And now you've waived the ability to now enforce the violation against me. Okay. So very important that you reflect any outstanding violations on the estoppel certificates. You'll also identify whether or not you have the ability to approve or disapprove sales, as well as whether you have a right of first refusal. Now, the statute does allow the association to charge for these estoppel certificates. So if the selling unit is not delinquent to the association, then the statute allows you to charge currently $299 for responding to the estoppel. If the unit happens to be delinquent, then in addition to the $299, you can charge a fee of $179. If the buyer has requested this estoppel certificate on an expedited basis, right? They want to close relatively soon and they need this ASAP. Well, you can charge an additional fee of $119, provided that you respond to this estoppel request within 3 business days of receiving the request. Okay. Now, if the association fails to deliver the estoppel certificate within the 10 business days of receiving the request, note that the association will not be able to charge the fee for preparing the response. Now, the statute does allow for and provides for additional fees that the association can charge in connection with the sale of multiple units. This most likely will not come into play, but I've identified the fee structure here if it does apply. Now, do note that these estoppel fees, right, they are subject to being adjusted every 5 years in an amount equal to the total of the annual increase for that 5-year period based on the Consumer Price Index, okay? Now, the adjustment is done by the Department of Business and Professional Regulations, or the DBPR. And whenever they do adjust the fees, they will publish the new fee schedule. Okay. So estoppel certificates, if you deliver the response by hand delivery or by email, which is the more typical way of delivering these responses, then they are effective for 30 days. If the estoppel certificate is delivered by mail, then it is effective for 35 days. Now, do note that the association cannot charge for an amended estoppel certificate. So if there's any revisions that need to be made, you'll not be able to charge any additional fees. However, the association can charge for a new estoppel certificate, even regarding the same transaction, if it is to be issued after the previous estoppel certificate expires. So if you've already provided a response to an estoppel request, and let's say the estoppel is good for 30 days, and let's just say the closing doesn't take place when anticipated, and for some reason the closing had to be postponed for another 30 days or whatnot. Well, if you are requested to provide a new or an updated estoppel certificate after the old one has expired, well, you can charge new fees for that. All right, other requested information that the association would have to provide. For example, associations or authorized agents may charge a reasonable fee to prospective purchaser, lien holder, the current parcel owner, or member for providing good faith responses to requests for information or on behalf of the prospective purchaser, so long as the fee does not exceed $150, plus the reasonable cost of photocopying and any attorney's fees incurred by the association in connection with the response. Sometimes you might have a situation where if the buyer is looking to obtain a mortgage, well, the lien holder might have a questionnaire that they might want the association to complete. Okay, so if you receive a questionnaire or request for additional information from a lien holder or even the prospective purchaser, well, this is where this fee would come up, right? If you need assistance from your legal counsel to provide a response, well, you can charge your attorney's fees to the purchaser or the lien holder, as well as this additional cost of $150. Now, the association and its authorized agents are not liable for providing the information requested in good faith if you include the following disclosure on the response. And the disclosure is here in italics. Essentially, the responses herein are made in good faith and to the best of my ability as to their accuracy. Okay, so you will want to make sure to include this particular disclosure in any response. Other purchase and sale documents include the condo question and answer sheet, which has to be updated annually and has to be maintained as part of the official records. For those of you who are not familiar with the condominium question and answer sheet, it is a form that you can download from the Division of Condominium website. So the Division of Condominium is the regulatory agency that essentially, governs and regulates condominiums in the state of Florida. They do have a website. So if you Google Division of Condominium, it should take you right to their website, and there should be a tab for forms, and you should be able to download this question and answer sheet. It is a single page, and it has several questions, including, for example, are you allowed to lease in your community? What are some of the use restrictions? And so you'll want to respond to these questions. And if you don't know the answers, you might want to get assistance from your legal counsel. And then once you respond to those questions, you keep that question and answer sheet as part of your official records, which prospective purchasers are entitled to receive. And then just note that the seller's duty to provide the buyer notice of all hidden defects. This, of course, is really not an obligation on the association, but rather just the selling owner. Some additional disclosures prior to sale. Each prospective purchaser who has entered into a contract is entitled to the following documents, which is your declaration of condominium, your articles, your bylaws, your rules, and your frequently asked questions and answer sheet. And typically these are provided by the selling owner. Unit owner disclosure prior to sale. There is also this form known as the governance form. And again, this governance form can also be obtained from the Division of Condominium website. And basically, we've identified here some of the subjects that the governance form has to address. For example, the role of the board in conducting day-to-day affairs, the board's responsibility to provide advance notice, the right of owners to attend and speak at board meetings, so forth and so on. You can read this list at your leisure. All right, let's move on to use right suspensions, voting suspensions, and fining. So the association has the authority to fine as well as suspend use rights of an owner, a tenant, an occupant, guests, licensees, or invitees for their failure to comply with your governing documents or association rules. Now, the authority to either impose a fine for covenant rule violations or to suspend use rights for covenant rule violations does not have to be expressly set forth in your governing documents. Some of your documents might already contain this authority, but if you have older documents that do not expressly give you this authority, don't be too concerned. The statute already gives the association the authority to fine and suspend use rights for violations. Now, the statute does provide for the mechanism or the procedure by which you have to follow in order to properly fine and suspend use rights. Okay. Now, I have seen governing documents that outline fining or suspension procedures, and sometimes, more often than not, that procedure is not in accordance with what the statute provides. So if you have one of those governing documents that already outlines a fining or suspension of use right procedure, just note that the procedure in the statute will control over whatever's written in your governing documents. So if whatever procedure you have in your governing documents, if it doesn't conform with what's in the statute, then do not follow that procedure. Okay, default to what the statute provides. And what the statute provides is essentially a two-step process. Okay, so the first part is that the board has to adopt the fine or the suspension at a duly noticed board meeting. However, that fine or suspension cannot be imposed unless the violating individual has gone before a committee hearing that must be noticed at least 14 days from the date that you provide notice of the committee hearing to the owner. Okay, so it's very important that you give the owner at least 14-day notice of this committee hearing. Now, the hearing must be held before an impartial committee of at least 3 individuals. And the role of the committee is limited to determining whether to confirm or reject the fine or use right suspension. So it is not the role of the committee to negotiate the fine, to negotiate the suspensions. The role is to confirm or reject the fine or suspension. So it's a yes or no vote. And if the committee rejects the fine or suspension, then it cannot be imposed. Now, the impartial committee has to consist of at least 3 members who are not officers, directors, employees of the association, or the spouse, parent, child, sibling of an officer, director, or employee. So yeah, I mean, I recognize that for some communities, especially if you're very small, this fining or suspension of use rights might not be a viable option because you're just not able to find these individuals who are impartial, right? And so if that's your case, well, just recognize that this particular remedy might not be a viable option for you, but there are certainly other remedies that are at your disposal for enforcing covenant or rule violations. Okay, and we do have a webinar that we teach on basically remedies for covenant enforcement. Okay, so fining and suspension of use rights is just one of many other remedies at your disposal. Now, if you are able to fine, then do note that under the current statute, the fine may not exceed $100 per violation, which may be levied on the basis of each day of continuing violation with a single notice and opportunity for a hearing, but may not exceed 1,000 in the aggregate. Okay. So let's take the example of a pet. Let's say that pets are prohibited in your condominium, and you've noticed that particular owner has recently brought a pet into their unit. Now, presuming that you have uniformly and timely enforced this pet restriction against all owners, right? So there are no potential defenses that could be raised. And let's say you send this owner a demand letter to remove the pet. Well, for each day that that pet remains in the unit, you can impose a fine of up to $100 with the maximum of 1,000 for that particular violation, right? Now, ultimately, if the owner does not remove the pet and you've gone through this fining process or you've suspended use rights, and the committee has confirmed the violation and confirmed the fine and suspension of use rights, and the pet still remains in the unit, well, you're going to have to exercise some other remedy to force the pet out, which might include mediation and instituting formal legal action. Okay. Now, the fine also cannot become a lien against the unit, and it is due 5 days after the date of the committee meeting at which the fine was approved. So currently under the statute, you cannot impose a lien or you cannot collect the fine through lien collections foreclosure process. So what that means is that if the owner does not voluntarily pay that fine, let's just assume, you've reached that $1,000 aggregate. Well, again, the violation still needs to be corrected. But in terms of collecting the fine, well, the fine will just be reflected on the account ledger. And hopefully, when the unit sells, you will reflect that fine on the estoppel certificate that we just discussed a few minutes ago. And that fine will be paid at closing. Okay. There is an option of pursuing a small claims action against the owner to recover this fine. But the reality is that it will cost you $500 to even file the complaint, not to mention attorney's fees in preparing the complaint. So unlikely that you will pursue legal action to recover the $1,000 fine. All right. So we talked about fining and suspension of use rights for covenant and rule violations. Well, the statute also allows associations to suspend use rights if an owner is delinquent on any monetary obligation owed to the association, which is more than 90 days delinquent. Okay. So if you have a situation where an owner is delinquent, and it could be on the monetary obligation can include any type of assessment, as well as administrative late fees if you're authorized to charge those, interest if you're authorized to charge interest, as well as attorney's fees, any costs incurred in collection, and it may even include a fine. Right. So if you've fined an owner and the owner hasn't paid, and now that fine is unpaid for 90 days, well, you have the option to also suspend use rights if, in fact, this is a viable option for your community. Now, With suspending use rights for delinquency, you don't need to go through the committee hearing. Okay, so that is a much simpler process. It just requires board action at a duly noticed meeting with notice of that meeting posted 48 hours in advance. So essentially, if you want to suspend use rights for delinquency, you post a notice of your meeting 48 hours in advance, and then you make your motions and you take your action at the board meeting. The use right suspension will then be effective until the monetary obligation is paid in full. Now, note that the suspension of use rights applies to common elements and common facilities, typically your pool, your clubhouse, maybe tennis courts, the gym, any association or any common facility to which you have the ability to control access. So if, for example, in your building or in your community, you can control access to these facilities through a fob system, which you can easily deactivate, well, then this would be a viable option for you. If you do not have the mechanism to control access into these facilities, well, you might be out of luck. This might not be a viable option for you, in which case you will have to then consider either fining or some other options for enforcement. Now, the statute does specifically say that the suspension does not apply to limited common elements intended to be used only by that unit. So, for example, if your condominium includes patios or balconies, you cannot suspend use rights to those particular limited common elements. Also, the suspension does not apply to common elements needed to access the unit. So hallways, for example, utility services, parking spaces, or elevators. Okay, so you cannot prevent an owner from getting in an elevator to access their unit or from parking in their assigned parking space. Now, you can also suspend voting rights if an owner is delinquent for more than 90 days. Suspension of voting rights also only requires board action, so you don't need a committee hearing. And it would apply if the owner is not only more than 90 days delinquent, but the actual delinquency amount has to be greater than $1,000. And then proof of the obligation must also be provided to the owner 30 days before the suspension takes effect. Now, case law did come out not too long ago that basically stands for the proposition that in order for the association to suspend voting rights, you either need to have express language in your declaration authorizing you to suspend voting rights, or you need to have what is referred to as Kaufman language in your declaration authorizing you to suspend voting rights. Kaufman refers to the words as amended from time to time, which typically follows reference to Chapter 718 of the Florida statute, and it's typically found, the first couple of pages of your declaration. So you might have something to the effect of, that this association is governed under Chapter 718 of the Florida statute, and then it might say as amended from time to time. So if you have that language, what that means essentially that any changes to the Florida statute, substantive changes to the Florida statute will retroactively apply to your community, and you will be subject to those changes in the law. So what the court in this case is saying is basically, if you have Kaufman language, then when the statute was amended to allow suspension of voting rights, well, that change in the statute will apply to your community. If you do not have Kaufman language, then you needed to have amended your declaration, or your original declaration needed to have included language that expressly allows you to suspend voting rights. So if you have neither, then consider amending the declaration to include one or the other. So that is a discussion that I would recommend you have with your legal counsel. Now, if you suspend voting rights, then the voting interest that's allocated to the unit cannot be counted towards the total number of voting interests for any purpose, including the number necessary to establish quorum and required to approve any action. So what this means is that, and this is why suspension of voting rights is, many communities find it beneficial. It's because, let's say you have a condominium of 100 units. And let's say quorum in your community is a majority of the owners. So that's 50% plus one. Well, if you have properly suspended the voting rights of 10 owners, then quorum would be based on a majority of the 90 owners, not a majority of 100. And let's say, similarly, you want to propose an amendment to your declaration, and the vote that you need to get is, let's say, 2/3 of the owners. Well, if you've properly suspended voting rights, and then the voting percentage that you need to achieve for the amendment to pass would be based on 2/3 of the 90 and 2/3 of the 100 units. So many communities find this beneficial, especially if you're trying to get an amendment or particular action passed, which requires an owner vote. All right. So let's shift gears now and let's talk about budget, reserves, and financial reporting. All right, well, we just went through a budget season. Typically, budget season, it's ranges from November through March, April of the following year. So many of you have had to adopt budgets. So hopefully this would just be a refresh of the process that you just recently went through. But essentially, every year, the board has to adopt an annual budget, which includes estimated revenues, operating costs, and reserves for the upcoming fiscal year. Now, the budget has to minimally include some of the following line items, and you might have more, you might have different, but typically a condominium budget will include line items for administration costs, management fees if you have management, maintenance, if you pay rent under a recreation lease, you would include that in your budget. Certainly taxes, insurance costs, professional expenses. So if you have legal counsel, or if you've had to hire an engineer, or you have a CPA, accountant, you would include those in your budget. Any security provisions or any other expenses. And then certainly you will include reserves and fees that are payable to the division. We'll talk about reserves momentarily. But essentially, the process of adopting a budget is that typically it is a process that's taken on by the board. So the board adopts the budget. And you have to provide owners with notice of the meeting at which you're going to adopt the budget, as well as a copy of the proposed budget at least 14 days prior to your meeting date. Now, if your bylaws provide for a greater time period, then you would go with what's required in your bylaws. Otherwise, the minimum statutory notice you have to give owners of your budget meeting is 14 days. Now, the statute also requires you to execute an affidavit attesting to your compliance with this notice requirement. Now, do note that if the board makes a change to the budget during the properly noticed board meeting, you do not need to resend or renotice the budget meeting. Okay, remember your budget is only an estimate, so while you've already provided owners with a proposed budget, if at the date of the meeting, you come across new information that will require you to modify the budget, well, you can still adopt the modified budget without having to renotice or resend the budget. Now, as of July 1st of 2021, the board is required to adopt the annual budget at least 14 days prior to the start of the association's fiscal year. Okay, so you'll need to determine when is your fiscal year. Okay, for most associations, it will be at the calendar year, but you might have a different fiscal year. So whatever it is, you need to adopt your budget at least 14 days prior to the start of that fiscal year. Now, if the board fails to timely adopt the annual budget a second time, according to the statute, this is deemed a minor violation and the prior year's budget will continue in effect until the new budget is adopted. Now, Alan talked about reserves briefly with regard to the structural integrity reserve study. What I'm going to talk about here is non-CEUs related reserves. Okay, so this will apply to all condominiums that are less than 2 stories, as well as any condominium that is 3 stories and above. So while the CEUs requirements were instituted for condominiums that are 3 stories and higher, the statute didn't eliminate the non-CEUs reserves for these associations, okay? So you still have a requirement to maintain these non-CEUs reserves. Now, I've included here definitions for capital expenditures and deferred maintenance, as well as giving you here some examples of reserve items that you will likely have in your non-CEUs reserves. Roof replacement is obviously now part of the CEUs, as well as building pavement, but you also could have pavement resurfacing or balcony restoration, sidewalk improvements, seawall replacement, air conditioning replacement, and so forth and so on. So these are just some examples. Now, what the statute provides and has provided for as long as I've been practicing law, and certainly far beyond that, is that a budget of a condominium association has to include reserves for capital expenditures and deferred maintenance for the following items: roof replacement, building painting, pavement resurfacing, and then any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. So obviously roof replacement, building painting, those are part of your CEUs. But if you are responsible for resurfacing your parking lot in your community, then pavement resurfacing is not going to be part of your CEUs reserve. It will be part of your non-CEUs reserves. And you might have other deferred maintenance or expense replacements that exceed $10,000, such as, for example, elevator modernization. If you're one of those buildings that requires that has an elevator. Okay, unless your engineer, reserve study specialist puts elevator modernization as part of the CEUs, it will likely be a non-CEUs reserve item. So just be aware of these reserves expenditures. Now, the amount to be reserved has to be computed using a formula based upon the estimated useful life and estimated replacement cost or deferred maintenance expense of each reserve item. So unless you're pooling reserves, and we'll talk about pooling in a little bit, your reserve schedule is going to include the bullet points that are at the end of this page. So you're going to have a reserve schedule that's going to identify the total estimated useful life of the asset, the estimated remaining useful life of the asset, estimated replacement cost or deferred maintenance expense, estimated fund balance as of the beginning of the period. So typically management will assist associations with preparing your reserve schedule. Alternatively, you can request your CPA to assist with this. Okay, but this is a reserve schedule that has to be included with every budget. If you are pooling reserves, then your reserve schedule will also include this information for the items that are in the pool. Now, Alan mentioned that for the CEUs reserves, you're not allowed to waive or reduce the funding of CEUs reserves. However, For non-CEUs reserves, you are still permitted to let owners vote to either waive or reduce reserves. Okay, so the board has to adopt the budget with fully funded reserves unless you give owners the option to vote to either waive those reserves or reduce the funding. And if you give owners this option, which is completely within the discretion of the board, then the vote that you need to obtain to either waive or partially fund reserves is a majority of the voting interest. So it used to be that the vote you needed to get was a majority of quorum, which is a significantly smaller percentage. Now that percentage has been increased to a majority of the voting interest. So if your voting interest is 100 units in the condominium, majority would be 50% plus one. As a practical tip, whenever you adopt the budget, if you're going to give the owners the option to waive or reduce reserves, then you will want to schedule that membership meeting first, and then schedule your board budget meeting after your membership meeting, right? Because at that point, you'll know whether or not the membership vote passed to waive or partially fund reserves. And at that point, at your board meeting, you can then decide, what kind of budget you're going to adopt. You can have your membership and your board budget meeting on the same date. Just notice your membership meeting first with the board meeting following the membership meeting. Now, reserve funds and any interest accruing on those reserve funds, right, must remain in the reserve account and can only be spent on the designated purpose for which these funds were designated. So if you have reserves for pavement resurfacing, then you can only use those funds for pavement resurfacing. You cannot use those funds for any alternate purpose unless the alternate use has been approved in advance by a majority vote of your voting interest. And again, this only applies to the non-CEUs reserves. You cannot use CEUs reserves for alternate purposes, okay? Now, in terms of pooling, non-CEUs reserves may be pooled. Well, you can also pool your CEUs reserves. You just cannot pool CEUs and non-CEUs reserves in the same account, right? And the benefit of pooling reserves is that if you've pooled reserves for, let's say, pavement resurfacing and let's say seawall repair, and this particular year, you absolutely have to repair your seawall, but you don't have enough funds allocated to the seawall repair. Well, you can use funds allocated to the pavement resurfacing if it's in the same pool without having to obtain a membership vote. At some point, you're going to have a discussion with your accountant to replenish those funds, but it gives you the flexibility of not having to obtain that membership vote in advance. If you are going to give owners the option to waive or reduce the reserve funding for non-CEUs reserves, then any limited proxy or ballot that you put out to the membership has to contain this disclosure in bold. Waiving of reserves in whole or in part or allowing alternate use of existing reserves may result in a unit owner liability for payment of unanticipated special assessments regarding those items. So essentially, you're letting owners know, hey, while we're giving you the option to vote to waive or reduce non-CEUs reserves, just be aware that if at some point we need to perform a major repair, you could be on the hook for a special assessment. All right, so we talked about budgets. Now we're going to talk about the financial reports. So within 90 days after the end of your fiscal year or annually on the date provided in the bylaws, the association has to prepare and complete a financial report of the preceding fiscal year. Okay, so if your bylaws don't provide a specific time frame within which this financial report has to be done, then it has to be completed within 90 days at the end of your fiscal year. Then, once you've completed this financial report, or more likely your accountant has completed this report, within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the association must mail or hand deliver to each unit owner a copy of the most recent financial report. And the word "and" will be changed to "or" effective July 1st. So you either have to give them a copy of the financial report, or you will have to provide them with a notice that essentially says, hey, the financial report is prepared and will be mailed or hand delivered to the unit owners without charge within 5 business days upon receipt of a written request from the owner. Okay. The association must also provide an annual report to the department containing the names of all the financial institutions with which it maintains accounts, and a copy of such report may be obtained from the department upon written request from the association. Now, we talked about having a financial report prepared, most likely by your accountant. Well, the level of financial reporting that you're going to have to prepare will depend on the annual revenue of the association, unless your bylaws expressly provide that you have to do an audit. If your bylaws require you to do a financial audit, regardless of what your annual income is, then you're going to have to do a financial audit unless you amend your bylaws to remove that specific requirement. Okay. If your bylaws are silent on requiring you to do an audit, then your financial report will depend on your annual revenue. Okay, so for example, if your total annual revenue is at least 300,000 but less than 500,000, then under the statute, you only have to prepare reviewed financial statements. If your total annual revenue is 500,000 or more, then under the statute, you will be required to do a financial audit. Now, owners can vote to reduce the level of financial reporting. Okay, so there is a mechanism for doing that. Obviously, the owners are going to have to vote. It's not a board decision. This is something that owners are going to have to vote on. However, last year, the statute changed to now say that you cannot reduce the level of financial reporting for consecutive fiscal years. So just be aware of that. All right, moving on to topic 4. We will cover notice, meeting requirements, insurance requirements, and then a little bit of conflicts of interest. All right, we're good in time. All right, so first we'll talk about membership meetings. So with membership meetings, first let me backtrack. Under the big umbrella or big picture, there's going to be 2 types of meetings. There's going to be the board of directors meetings, and board of director meetings are meetings at which the board votes and takes action. And then you're going to have membership meetings, and membership meetings are meetings at which owners vote. There's no such thing as just an association meeting. It's either a board meeting if the board needs to vote on something, or it's a membership meeting if the owners are actually requested to vote on a particular action. Now, within the umbrella of membership meetings, you will have 2 types of membership meetings. There is the annual membership meeting, okay, and that is the meeting at which you will have your election. If nothing else, that is the one meeting that you are required to have annually, your annual membership meeting. Any other meeting that you will have of the members throughout the year, other than your annual meeting, will be a special membership meeting. Okay, so I want you to just kind of keep these categories sort of in front of your mind when I talk about these meetings. All right, let's talk about the annual membership meeting. So the annual meeting of the unit owners has to be held at the location provided in the bylaws. And if your bylaws are silent, the meeting has to be held within 45 miles of the condominium. Typically, if your bylaws specifically require you to hold your meeting at a certain location, we recommend, if you want to have flexibility, to amend that out and instead give you the authority to conduct meetings at reasonable locations, but as determined by the board. Okay. Now, the bylaws have to provide the method of calling meetings of unit owners, including annual meetings. And then your election will occur on the date of the annual meeting. So Alan already went through that process. Now, special membership meetings refers to, like I said, membership meetings other than the annual meeting. Now, typically they're held when either called by the board. So when the board wants to present an issue to the owners for a vote, typically the board will notice a membership meeting, or a special membership meeting can be requested upon written request of at least 10% of unit owners, unless there's a different percentage provided in your governing documents. So this could come up, for example, if owners are looking for an amendment to a particular document, governing document. They could petition the board to hold a membership meeting for purposes of voting on that particular amendment. Your written notice of a membership meeting has to include an agenda, date, time, location, and it needs to either be mailed, hand-delivered, or electronically transmitted to unit owners at least 14 days before the meeting, as well as be posted on condominium property at least 14 days prior to the meeting, unless, of course, your bylaws provide for a greater time period, in which case you go with that. If you are going to mail notice, then note that the notice has to be mailed to the owner at the address that was last furnished to the association. Now, the person that's providing the notice, typically it could be the secretary or your property management team. They have to provide an affidavit attesting to complying with the notice requirements. Now, in addition or in lieu of the physical posting of the meeting notice, the association may adopt reasonable rules and procedures for conspicuously posting and repeatedly broadcasting the notice and agenda on a closed circuit cable television system serving the association. So this could be beneficial if you are one of those condominiums that have a bulk service contract. If you do, this could be an option. If not, then that's okay too. Now, the association may opt to deliver meeting notices by electronic transmission by following these rules. As you might be aware, electronic notices can only be sent to unit owners who consent in writing to receiving official notices by electronic transmission. So you can't just, email notices of meetings to owners. You could do it as a courtesy, but if you want email notification to be your official form of notification, it would only work if you send those email notices to only owners who have already consented in writing to receiving notices by email. If you don't have this consent in writing, then you will need to either mail or hand deliver notices of the association to that particular owner. The written consent must be signed by the owner of record or a person holding a power of attorney executed by the owner of record. And then the consent to receiving notices by email may be delivered to the association by email, hand deliver, mail, or certified mail. And the unit owner bears the risk of ensuring delivery. Now, note that electronic notices cannot be used for recall of a board member or for noticing a membership meeting in which the vote to forego retrofitting the condominium with a fire sprinkler system is to take place. And then notices of a meeting is effective when sent by the association, regardless when the notice is actually received by the owner. The association is required to maintain email addresses and fax numbers for those owners who have consented in writing to receiving notices electronically. Just do be aware that if an owner has consented to receiving notices electronically, then those email addresses do become accessible to other owners. So that means that if an owner makes a request for email addresses of other owners in the community and you've consented to receiving notices electronically, well, that email will have to be disclosed. And then the association cannot sell or share email addresses or fax numbers with outside third parties. Now, Alan did discuss website requirements. Just again, as a reminder, for currently associations managing condominiums with 150 or more units, you also have an obligation to post a copy of your notice on your website at least 14 days before the meeting. And you also have an obligation to post any document that is associated with that membership meeting at least 7 days prior to the meeting. So for example, if you're looking for owners to vote on a proposed amendment to your governing documents, well, you have to post that proposed amendment in addition to the notice on your website. If you're a condominium with less than 150 units and you don't have a website, you might want to consider posting notice of the meeting and any associated documents on the website anyways. And certainly that requirement of the website requirement will change effective January 1st. Now, quorum for membership meetings, unless you have a lower number in your bylaws, quorum is going to be a majority of the total voting interest. And then unless otherwise provided in the statute or in your association governing documents, decisions to be made by the members have to be made by a majority of the voting interest represented at a meeting at which a quorum is present. So that is not a majority of the total voting interest. That would be a majority of quorum. What that means is, for example, if, again, let's go with your condominium of 100 units, to use easy numbers, and let's say your quorum is a majority of the voting interest, so that's 50% plus 1 of the 100. And let's say that the minimum number of owners that showed up at this particular meeting was 51, majority. A majority of quorum means you would need to get 50% plus 1 of the 51 owners in order for a particular action to pass. Okay, that's what that means. Now, written consent, we've talked about membership meetings, right? Where you duly notice a meeting and then you provide limited proxy for owners to vote if they can't make it. There is an option for owners to also vote by the written consent process in lieu of the board having to notice a membership meeting. With the written consent process, you can do this if it's expressly authorized in your governing documents. And essentially with the written consent process, you would mail to or provide to the owners a notice or some memorandum identifying the particular action that you want owners to take with, for example, approving a specific amendment. And then at the bottom of that form, you will include a signature line where the owner who is consenting to that particular action can sign the consent form and then return it to the association. So essentially, only if you are in favor of the particular action do you have to then sign the consent form and return it to the association. And if you do follow this process, you don't have to have a membership meeting. And you have 90 days from the first executed consent form within which to obtain the consent form from whatever percentage of owners you're required to get in order for this particular action to pass. So if you are interested in having the flexibility of owners voting by written consent process, and this certainly was a viable option for many associations during COVID, then speak with your legal counsel, okay? Members have the right to speak at membership meetings, excuse me, with regard to all agenda items. But the association may and should adopt reasonable rules governing the frequency, the duration, and the manner of member statements. Now, a member may also record or videotape a meeting subject to reasonable rules adopted by the division, which I've identified here, and you can read at your leisure. Now, voting by proxy. This obviously will come into effect if owners, if you're having a membership meeting. Okay, this is not applied by the written consent process. So there's two types of proxies. There's a general proxy, and then there's a limited proxy. General proxies will allow the proxy holder to vote however the proxy holder sees fit on any matter that may be undertaken at the specific meeting. Generally, a general proxy, well, both general proxies and limited proxies can be used to establish quorum, but limited proxies are what is used when you need owners to vote on a specific issue. And certainly the statute requires limited proxies if you're looking to get owners to vote to waive or reduce reserves. Or vote to waive financial reporting requirements, certainly to amend any of the governing documents, and for any other matter for which the Condominium Act requires or permits a vote of the owners. So with a limited proxy, essentially you will identify on the proxy form the specific question or proposal which you are seeking owners to vote on, okay? With a general proxy, typically that's used simply to establish quorum at the membership meeting, typically with the annual meeting. Not for purposes of the election, but if, for example, the board is looking to present reports of committees, etc., you'll want to send out a general proxy just to establish quorum, even though owners are not really voting on anything, just so that the board can proceed with the rest of the agenda of the annual meeting. Now, proxy cannot be used to vote in an election or to vote to forego retrofitting. And the proxy is good for 90 days after the date of the first meeting for which it was given. So that means is that if you hold your membership meeting and on the date of the membership meeting, you counted your proxies and your ballots and you don't receive the vote that you need for the particular action to pass, well, you can recess and reconvene that meeting for as many times as necessary up to that 90th day to see if you can obtain the votes that you need. Okay, and that's because the proxy is good for 90 days. Now, if you come to that 90th day and you still don't have enough votes, well, at that point, the issue essentially dies. You'll adjourn the meeting and you will have to again present the issue to the owners if you want to try again. Okay, there is a mechanism for recessing and reconvening a membership meeting that you might want to speak with your legal counsel about. And then every proxy is revocable at any time at the pleasure of the member executing it. All right, let's go on to board of director meetings. So the officers and directors have a fiduciary responsibility to the unit owners and must act reasonably. However, the board must exercise its best efforts to purchase insurance, rely on the advice of guidance of experts, so forth and so on. The directors must not be compensated unless otherwise authorized in the bylaws. And then unless otherwise provided, the corporate powers of a corporation are exercised by the board. So what that means is that really no individual board member, not even the president, should make any unilateral decisions, right? Rather, the board must act making decisions at properly duly noticed meetings. And the board is generally responsible for the maintenance and operation of the association property, as well as the health, safety, and welfare of owners. Now, the statute does prohibit kickbacks. This went into effect a couple of years ago. The statute defines what a kickback is, which is anything or service of value for which consideration has not been provided for an officer, director's, or manager's own benefit, or that his or her immediate family from any person providing or proposing to provide goods or services to the association. And the statute essentially says that an officer, director, or manager may not solicit, offer to accept, or accept a kickback. Now, an officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony of the third degree, and it's subject to civil penalties and must be removed from office and vacancy declared. However, there is no prohibition against an officer, director, or manager from accepting services or items received in connection with trade fairs or education programs. So, typically there's several trade fairs, trade shows throughout the year in different locations throughout the state where vendors that service the condominium and HOA communities provide goodies. So you can attend these trade shows, you can get all those goodies, and that would not be considered a kickback. Now, an association, its officers, directors, employees, and agents may not use a debit card issued in the name of the association or billed directly to the association for the payment of any association expenses. This went into effect July 1st of 2024. And a person who uses a debit card issued in the name of the association or billed directly to the association for any expenses that is not a lawful obligation for the association commits theft. So obviously the legislature is trying to phase out the use of debit cards. Use of credit cards as of now is still allowed. Now, a director or officer charged by information or indictment with any of the following crimes must be removed from office: forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement involving association funds or property, destruction or refusal to allow inspection or copying of an official record of association which is accessible to owners within the time period required by law in furtherance of a crime, obstruction of justice, and then certainly any criminal violation under the Condominium Act. The board must fill the vacancy until the end of the suspension period or end of the director's term, whichever occurs first. And if the charges are resolved without finding of guilt, the director must be reinstated for the remainder of his or her term. And a director who has such charges pending may not be appointed or elected to a position as a director or officer and may not have access to the official records except pursuant to a court order. So there are 6 ways that you can essentially get off the board if you're no longer interested to serve on the board. You can resign in writing. You can get recall, which is the process excuse me, which is a process by which the owners vote to remove a director from the board. If you are delinquent in the payment of any monetary obligation due to the association for more than 90 days, you're deemed to have abandoned your seat, creating a vacancy. The board doesn't have to have a formal meeting to get you removed from the board. Okay, you're automatically deemed to have abandoned your seat if you're more than 90 days delinquent. So you want to make sure you're not delinquent on association on any association charges. Criminal charges involving theft or embezzlement of association funds or property will certainly get you kicked off the board, as well as for a knowing and willing violation of condominium. The division may order removal of the officer or director and can levy fines, and then failure to satisfy your certification requirements. Okay, you will be suspended until you comply with your certification requirements, which is why you're here. All right. Additional information you need to know when you conduct your board meetings. These are some of the changes that the first two went into effect July 1st of 2024, so last summer. In a residential condominium association of more than 10 units, the board must meet at least once each quarter. Okay, so it's not good enough that you have a board meeting once a year or 5 board meetings, at the beginning of the year. You have to have at least 1 meeting each quarter, and then at least 4 times each year. And the statute doesn't say when, but at least 4 times each year, the meeting agenda has to include an opportunity for members to ask questions of the board. Okay, now the statute doesn't say that the board has an obligation to answer any of those questions, but you have to give owners the floor and the opportunity to ask those questions. Now, at times, the board may take action outside of the context of a properly noticed board meeting, such as in the event of an emergency. Well, the law does allow you to ratify those decisions at your next properly noticed meeting. So be sure that you do that if you've made decisions outside of a duly noticed board meeting. And then the statute expressly says that board members may use email as a means of communications, but cannot use email to cast a vote. Okay, so make sure you're not voting by email. Now, typically, notice of board meetings must be posted on condominium property at least 48 hours prior to your meeting, except in case of an emergency. However, the statute does require 14-day notices in 2 specific instances. If you're going to adopt a non-emergency special assessment or an amendment to the rules regarding unit use. So we're not talking about amendments on, use of the pool or the pickleball court. We're talking about amendments concerning rules regarding unit use. Okay. For those meetings, you have to mail, deliver, or email to owners, as well as post on association or condominium property notice at least 14 days prior to the meeting. And then you also have to get an affidavit signed by the individual who provided the notice, attesting that you have met the notice requirements. For those of you who have a bulk cable service, you also have the option to post and broadcast notice and your agenda on a closed circuit cable television system. And again, website requirements for those of you that are currently under the website requirement, make sure that you also post copies of the board meeting notices on the website at least 48 hours or 14 days prior to the meeting, depending where you fall in. If you are not required to have a website, but you have a website, then you might want to consider also posting copies of notices on the website. All board meeting notices have to specifically identify agenda items. Now, sometimes you may have posted notice on the you may have provided notice of a board meeting with certain agenda items, but maybe something came up in the time between the date you posted notice and your meeting that you need to take up for discussion on an emergency basis. But that particular issue is not on the agenda. Well, if a particular issue is not on the agenda, it may be taken up on an emergency basis by a vote of at least a majority plus 1 of the board members. Okay. Now, if you do that, make sure that you ratify whatever decision you made at that meeting on an emergency basis at your next duly noticed board meeting. If 20% of the voting interest petition the board to address an item of business, then the board, within 60 days of receiving that petition, have to place that item on the agenda of its next regular board meeting or special meeting called for that purpose. Okay. Now, if you're going to consider a contract, approving a contract for goods or services, then a copy of the contract has to be provided with the notice and has to obviously be made available for inspection and then copying upon a written request of the unit owner. And then notice of any meeting at which a regular special assessment is going to be considered has to specifically state the assessment will be considered, provide the estimated cost, and then the description of the purpose of that assessment. Meetings of the board at which a quorum of the board is present must be open to all owners, except in 2 instances where owners are not allowed to attend the meetings. And those include meetings between the board and the association's legal counsel with respect to proposed or pending litigation, as well as meetings held for the purpose of discussing personnel matters. So for those meetings, you will still duly notice the meeting, right? So you still have to post notice of the meeting, but you will identify on that notice that the meeting is closed, right? Either for purposes of discussing personnel matters, or it's a closed meeting with association legal counsel to discuss proposed or pending litigation. A unit owner can also tape record or videotape meetings of the board, subject to the reasonable rules adopted by the division, which we've posted them here and you can read at your leisure. Now, owners have the right to attend board meetings as well as the right to speak at the meetings with reference to all designated agenda items. And what was recently added in the statute is that owners also have the right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and any other issue affecting the condominium. As I already mentioned, association may and should still adopt written rules governing the frequency, the duration, and the manner of member statements. A majority of the board present at a board meeting will typically constitute a quorum. Now, board members and committee members can meet by telephone. They can also meet really any real-time by any real-time electronic or video communication, so via Zoom or Teams meeting, as long as there's an ability for everyone to hear the board members. Okay. Now, unless otherwise provided in the Florida statute or in the association's governing documents, actions of a majority of the directors present at a meeting at which a quorum has been attained constitutes actions of the board. Directors cannot vote by proxy or by secret ballot at board meetings, with the only exception, which Alan discussed, is when electing officers, which can be done by secret ballot. And then a director who is present at a board meeting on which action on a corporate matter is taken is presumed to have assented to the action taken unless he or she votes against the action or abstains from voting. And a vote or abstention for each director present must be recorded in the minutes. Now, committee meetings. Meetings of a committee that are specifically for purposes of taking final action on behalf of the board or to make recommendations to the board regarding association budget, they are always subject to meeting notice requirements, right? They can be exempted, so they have to be noticed. Now, if we're talking about meetings of committees that do not take final action on behalf of the board or make recommendations to the board regarding association budget, so for example, committee hearings on finding or suspension of use rights, they can be exempted from the mandatory notice requirements only if the meetings are exempted by the association's bylaws. Okay, so Typically, bylaws do not specifically exempt these types of committees from the meeting notice requirements. So this means that you'll need to amend your bylaws to specifically exempt them from the notice requirements. Otherwise, essentially all committee meetings are subject to notice requirements, and you have to allow owners to attend. Okay. Maintaining insurance, we're good in time. I think we have this and conflicts of interest, so we are very close to being done. So hang on, hang in there. We're almost there.
Thanks for that heads up. Oop, I just turned my camera off. Just a reminder, folks, as we head down the home stretch here, Kerstin, great job, by the way. Not losing your voice. I'm impressed. If you haven't already pressed the chat button, press it one time, simply so it appears on your screen. Do not worry that it will say chat is disabled. Nothing for you to enable. We can still send stuff your way. And as Kerstin heads towards the last few slides in a little bit, that's where we will place the evaluation link into that chat area. Okay, back to you.
Okay. All right, maintaining insurance. So associations have to use their best efforts to obtain and maintain adequate insurance to protect association property, and the common elements. Now, adequate property insurance is going to be based on the replacement cost of the property to be insured, which can only be determined by an independent insurance appraisal. And that appraisal has to be updated at least once every 36 months. Okay, so you should have an insurance agent. They're the ones you need to speak with regarding all your insurance needs, right? Now, in addition to property insurance, the association, you will want to discuss with your insurance agent obtaining liability insurance for directors and officers. So that's typically referred as D&O insurance. And that covers errors and omissions of directors and officers. So claims for typically breach of fiduciary duty or negligence, they would likely be covered by your D&O coverage. As well as insurance for the benefit of association employees, and then flood insurance for common elements, association property and units, which will likely depend on whether or not you're in a flood zone, but it could still be beneficial for you to get flood insurance, even if you're not in a flood zone. So these are the questions, discussions you're going to need to have with your insurance agent. The association is required to also maintain what is known as fidelity bond, okay, or bond insurance for all persons who control or disperse funds of the association. And that term, persons who control or disperse funds of the association, includes individuals authorized to sign checks, as well as the president, secretary, treasurer, and certainly property management. Your fidelity bond coverage must cover the maximum funds that will be in custody of the association or its management agent at any one time, and the cost of the fidelity bond coverage will be an association expense. Now, effective July 1st of 2024, if the division receives a complaint, the division will monitor an association for compliance with the statutory insurance requirements and may even issue fines and penalties established by the division for the failure to maintain the required insurance policies. Now, what are you required to insure? Well, for any policies on or after January 1st of 2009, so this applies to all of your insurance policies, your property coverage must provide primary coverage for all portions of condominium property as originally installed or replacement of like kind and quality, as well as all alterations or additions made to the condominium property or association property. This excludes from association coverage, obviously, unit owner responsibilities, which we'll talk about in a minute. So as of July 1st of 2010, the statute was amended to remove the ability to force place a unit owner's coverage, insurance coverage on a unit, okay? So the statute currently doesn't require owners to maintain any level of insurance, okay? Nor is there really a mechanism for the association to, that I'm aware, for the association to purchase and then force place that coverage on the owner. There is possibly an option to require owners to maintain certain insurance by way of an amendment to your declaration of condominium that obviously will require membership approval. But there are some drawbacks in doing so, and so you will want to speak with your legal counsel about whether or not proposing an amendment to your declaration to require owners to maintain certain insurance would be beneficial to your community. Now, the association's coverage has to exclude all personal property within the unit or limited common elements, including floor, wall, ceiling coverings, electrical fixtures, appliances, water heaters, water filters, building cabinets, curtains, drapes, blinds, etc. Okay, such property and the insurance thereon will be the responsibility of the unit owners, but as I just mentioned, the statute doesn't require owners to maintain insurance to cover these items that I've just read off. It just says that these are the insurance obligations of the owners. Now, owners are responsible for the cost of reconstruction of any portion of condominium property for which the property insurance and the cost of any reconstruction done by the association is chargeable to the unit owner and can also be enforced and collected as an assessment. Now, if you have a casualty event, right? So casualty event will typically include things like a sudden burst pipe, or for example, a hurricane. If you have one of these casualty events that causes damage to condominium property, then any portion of the condominium property that must be insured by the association, which is damaged by an insurable event, must be reconstructed, repaired, or replaced by the association as a common expense. Okay, so typical one that comes up often is damage to drywall, which is considered a common element. So if you had wind-driven rain as a result of a hurricane and it causes damage to drywall within a unit, that is typically damage that is considered an insurable event and an obligation of the association to repair, replace as a common expense. Now, unit owners are responsible for the cost of reconstruction of any portion of the condominium property which the unit owners require to carry property insurance. So in the previous slide, I read off the items that owners are responsible for insuring. So if there is an insurable event that causes damage to any of that personal property, well, that would be the obligation of the owner to repair or replace. As well as owners are responsible for the cost of reconstruction of any portion of the condominium property not paid by insurance proceeds, if that damage is caused by the intentional conduct, negligence, or the failure of the owner to comply with the governing documents. And then the cost of any such reconstruction work undertaken by the association can certainly be recovered as an assessment against the owner. Now, in the absence of an insurable event, the association or unit owners are responsible for the reconstruction, repair, replacement as determined by the maintenance provisions of the declaration. So if there is damage to, for example, a window, or if there's damage to the unit resulting from a leaky toilet, right? That's more unlikely that is covered by that is considered an insurable event. So that type of damage, who's responsible for repairing it, will be determined based on the maintenance responsibilities that are set forth in the declaration. All right. And then the final section we'll talk about now is conflicts of interest, and then you guys are off the hook. All right. Let's get through the next few slides. All right, board of directors conflicts of interest. So directors, officers, and relatives of the directors and officers have to disclose to the board any activity that may reasonably be construed to be a conflict of interest. Well, there is a rebuttable presumption that a conflict of interest exists if any of the two following things occur. Either the director, officer, or relative of the director or officer enters into a contract with the association for goods or services, or these individuals have interest in an entity that is looking to enter into contracts for goods or services with the association. So, for example, if one of your directors owns a plumbing company, John's Plumbing, and the director is looking to provide some kind of plumbing services to the association, obviously there is a conflict of interest. And so this is these are the steps that you would need to follow in order to properly approve that contract. So essentially, if a proposed activity is there's a conflict of interest on the proposed activity, then all the contracts and the documents related to that activity have to be attached to the meeting agenda. Obviously, you'll properly notice a board meeting to discuss this potential conflict of interest. And then the contract or the transaction that is subject to the conflict of interest will have to be approved by 2/3 vote of the directors present at the meeting. The director, officer, or relative of the director or officer who is a party to this conflict can still attend the meeting, which the board will be voting on the transaction, and can also make a presentation to the board regarding the proposed contract or transaction. Now, after the presentation, this individual must leave the meeting during the discussion. The attendance of the director officer with a specific conflict of interest will be counted towards establishing quorum, even if they leave after the fact. And then certainly that director officer who is a party to this conflict of interest has to recuse himself or herself from the vote. Now, once the board has voted and approved the transaction or the contract that is subject to the conflict of interest, at the next regular or special meeting of the owners, the board has to disclose this contract or transaction. And then upon a motion of any member of the association, the contract may be canceled by a majority vote of the members who are present. So even though the board can still approve a contract or transaction that is subject to conflict of interest, the owners do have the opportunity to cancel that vote by a vote of the majority of the owners who are present. Now, if the membership ends up canceling that contract or transaction, then the association is only liable for the value of goods or services provided up to the time of the cancellation, and you will not be on the hook for any termination fees or any liquidated damages. If the contract entered between the director, officer, or relative of these individuals and the association has not been properly disclosed as a conflict of interest, then under the statute, that transaction is voidable and can be terminated upon a vote of at least 20% of the voting interest of the association. Okay. And then you still have the obligation to post a copy of that proposed or that approved contract on your website if you fall within the website requirements. All right, and then similar conflict of interest provision for conflicts of interest affecting community association managers and management firms. So a property manager or a management firm, including their directors, officers, and any person with a financial interest in the management firm or any relatives of these individuals, they also have to disclose to the board any activity that can be reasonably construed as a conflict of interest. And a conflict of interest is presumed if either of these two bullet points apply. Either the property manager or management firm or any directors of the management firms or relatives of these individuals either enter into a contract for goods and services with the association, or they have an interest in an entity that is looking to enter into a contract or transaction with the association. So very similar requirements. The disclosure of the conflict of interest has to be obviously reflected in the notice of the meeting at which this is going to be considered, as well as disclosed in the minutes. And then the proposed transaction that's subject to the conflict of interest has to be approved by a vote of 2/3 of all directors who are present. And then again, at the next regular or special meeting of the members, the existence of the conflict of interest, as well as the contract, has to be disclosed to the members. If a property manager or management firm has previously disclosed a conflict of interest in an existing management contract between between management and the association, then that conflict of interest does not need to be additionally noticed and voted during the term of the management contract. But upon renewal, it must be noticed and voted in accordance with the requirements that I just read off. If the conflict of interest section that we just went over is violated, then the association can cancel the management contract with management or management firm. And then similarly, if that contract is canceled, the association will not be on the hook for any termination fees or liquidated damage, only for the cost of services rendered up through the date of termination. Failing to disclose any conflict of interest also constitutes grounds for which disciplinary actions may be taken. All right, and we just got to the end of the slides. That concludes this condo board certification class. Jeff?
Well done. Well done. I know you're going to go through a few of the questions. And while you're looking through some of those, Kerstin,
Yes.
folks, please keep in mind we just placed a link for the evaluation into the chat for a second time. So it's in there. If you have not yet pressed the chat button so it appears, do so now, because if you do it after we place the link in there, you won't see anything placed in there beforehand. So press the chat button one time so it appears if you haven't already done so. And in about a minute, I'll place the link in there once again so you can see it. After you, now please listen up. I get this question in the Q&A a lot, even though I've repeated over and over again. We would love for you to hang out for the Q&A, but it's not required. After you fill out the evaluation and after you press the link and fill out that evaluation, you do not have to remain on. The required portion is now over. As you've just heard Kerstin say, that does it for the condo certification class. The class is completed. So click the link, submit the evaluation. After you submit the evaluation, the confirmation screen will have contact information for the fine folks at Empire, as well as us with K. Bender Rembaum, and also a link to download and save the slides. After Kerstin does a few of the Q&As and Kerstin and Mike and Jose sign off, I will remain on for a few minutes to more slowly go over the evaluation process for anybody who might be having any technical issues. So with that said, Kerstin, I will now shut my mouth and turn it back over to you.
All right, let's see here.
Just place the link in the chat once again, so it's in there for a third time, folks.
This is funny. So are you saying that there is really no recourse when a person is fined or doesn't pay? Well, I'm not sure what well, it's I mean
Alan mentioned earlier he doesn't believe in fining, thinks it doesn't. So I think that might stem from that. He thinks
yeah,
it's
I
kind of
mean
doesn't do much for anything.
yeah, I mean, I'm not a big fan of fining or suspending use rights. I mean, these are available remedies if you are able to get your committee together. But you know, oftentimes associations just don't have the ability to control access to these facilities. And so that's often not a viable remedy. And with fining, you're right. The statute currently doesn't give you the ability to collect the fine as an assessment, which surprisingly, the HOA statute does allow this option. But current state of the law, this does not apply to condominiums. So you always have the option of mediating and then ultimately pursuing legal action. And that really is going to be your ultimate legal recourse if you want to basically, you know, force a compliance. Okay, so don't forget that that is a remedy. Okay, let's see here.
Thank you, Veronica. We appreciate the kind words.
Yes. Let's see. If we need to approve a repair for a specific unit, can we approve the repair by email between us as a board and management companies? Well, the statute does say you cannot vote by email. So you can use it as a mechanism to communicate. I suppose you can agree that a certain unit needs repairs, but you do need to ultimately approve that repair at a duly noticed board meeting. Let's see here. If a board member uses personal funds to purchase items to be used in maintaining a facility, does the reimbursement need to be ratified at a meeting? I mean, certainly. Certainly, it's an expenditure of the association unless there's some there was some kind of resolution passed or board meeting held at which that initial expenditure was already approved for reimbursement, authorized and then approved for reimbursement, excuse me. Our board votes by email on pretty much everything and then ratifies decision in the next meeting. Is that allowed? I mean, you know, ratification is certainly a remedy available to ratify decisions made in situations that you can't hold a meeting right away, right? So it's not intended to be your you know, normal course of business. So I would go get away from that and try to you know, to have your duly noticed board meetings or your resolutions signed in advance. Also, what is the point of voting on a ratification if it can't be voted down? Not sure what that means, but presumably if you've already kind of voted in advance by email in particular action, then you're essentially ratifying. Can't imagine that any member would disagree at that point, but could happen.
And that's, like you said just a moment ago, that's more for the extenuating circumstances. That's not something that should be done with regularity, correct?
Mm-hmm.
Yep.
Notice, nice to see that you identify associations as not-for-profit as opposed to a non-profit. Some may know. Okay, sorry, different comment. Okay, let's see here. Will you, this is more for you, Jeff. Will you post a presentation in the chat or will you receive it by email?
Oh, I'm going to go over that more slowly once again, but as we mentioned before, the link for the slides will be on the screen after you submit the evaluation for which the link was placed into the chat. So click the link in the chat. Evaluation opens in another tab on your browser. Fill out the evaluation, hit submit. Then the successful submission, you get another screen with a shaded box. One of the links in that shaded box is the link to download and save the slides. If you are referring to a video recording of this webinar where you hear us and see us like you are right now, that will be on kbrlegal.com within a few business days. We just do some minor editing to get rid of all the non-vital stuff.
Okay, I think maybe last question here at the bottom, if votes are by email, then the owners will not be able to participate or provide comments and issues. That is correct. And this is why you need to have open meetings, as opposed to just ratifying decisions after the fact.
Yeah.
All right.
Extenuating circumstances only. I know you have another meeting to get to, Kerstin. Mike or Jose, I'm not sure if you're still around. If you are, you want to come on back and give some parting words. It's been a great day. We appreciate you inviting us to collaborate on this. As always, we enjoy working with y'all. Thanks once again. Before I go, I'll remain on for a few minutes afterwards after our parting words from our co-host today. So Jose or Mike, thank you both.
Well, Jeff, thank you very much. Thank you, Kirsten and Alan, for all the time today to educate everybody. Thank you all for being board members. At the end of the day, you've
Yeah,
realized that it's either a thankless job and that all of a sudden you are required, between quotes, in knowing a lot more than what you believe you have to. So please rely on your managers, whether they're mine or anybody else's. We are professionals for a reason. There is a license that now with new regulations, if you attend the new updates with HB 913, new regulations that we have to adhere to, and so do boards. And that's one of the reasons why we have Mike to ensure that boards stay fully compliant with the new changes as we go through. Again, we service all of Florida, but in person from Sarasota through Orlando, Tampa, Jacksonville, Daytona, and St. Augustine. If you guys even just want to quote, have questions, want to compare, or if you just want to spill out the drama that's worth of a Netflix episode with somebody, we're here to listen and help. Thank you. I appreciate your attendance.
Thank you, Jose.
Thank you,
Kurt?
everyone. I really do appreciate everyone joining today and look forward to making contact again in the future and future educational opportunities. And we're here for you if you need us.
Thank you so much, Mike. Thank you, Jose. Kerstin, any parting words before you head out? I know you have a radio show this evening.
Oh, that's right. 5 o'clock for those who want to hear some more about Condo HOA World.